Morning, everyone. This is a regular meeting of the members of the State Liquor Authority. Today is June 26, 2019. Presentator Chairman Bradley, Commissioner Ford, Deputy Commissioner Licensing Rogers, myself, Secretary to the Authority Donahue, and Acting Councilor Furry. The next meetings of the Authority are July 17th. This will be a 3-week break until the next meeting. Then July 31st, and then August 20th. So there'll be another 3-week break between the last August meeting and the only meeting we're having in August, which would be a Tuesday. We're going to call items first in the order they're assigned in. First in Buffalo, then Albany, and then starting at 11 o'clock in New York City. If there are matters with people here in Albany as well as New York, we'll probably hold those until toward the end of the Albany calendar. If you have a cell phone, please silence it. If you need to take a call, please go outside. When your item is called, please approach the podium, whether it's here or in New York or Buffalo. State your name and please speak clearly. Here the microphones are on the table in front of the podium. Secretary's office has one announcement to make. Donald Roper, who is our Excelsior Fellow assigned to Secretary's office, is being admitted to the bar today. So he's making a little guest stop here before he heads over to the Empire Convention Center to be sworn in. With that, Chairman, I will see.
He's in the room here?
He's right back there.
Sure you want to go down that road?
I tried to talk him out of it.
Congratulations.
Do you have any announcements, Chairman?
I do not.
All right. And we're going to proceed then with the first item in Albany, which is item 1249. We don't have any items in Buffalo. 1249, Windmill Wine and Spirits, LLC.
Chairman, Commissioner, just so you know, this is a question to consider public convenience and advantage for a new liquor store. Disregarding what's on there right now, public convenience. Who's up?
Is there any opposition here?
If there's opposition,
Put your name on the record.
Opposition first, please.
Yeah, but we're going to know. Put the applicant, put your name on the record, then we'll get from the applicant.
Nick Werner as representative for Dallas Gilpin Windmill Wine and Spirits.
Thank you. Come on up.
Good morning. My name is Peggy Schwartz. I am the owner of Town and Country Liquors in Sotheby's, New York. I've owned that store for almost 41 years. I'm here to speak why I feel Sotheby's does not need another liquor store. We have a population of about 19,000 people in Sotheby's. Ever since the year 2010, the population has been steadily decreasing. We need more businesses that will bring tourism into our area, and a liquor store is not what will bring tourism into our area. We have 2 existing stores servicing the area right now. If there is a 3rd store, that will not bring new business in, that will only take away from the 2 stores that currently exist and will really thin the revenue out for the 2 existing stores. There has never been a surviving 3rd liquor store in Sotheby's for many reasons. One of them is any store that has attempted to be in the village of Sotheby's has not succeeded. And I think one of the reasons is it is a pedestrian area and the traffic in the village is horrendous. And having a store there that will bring in trucks will take away from the commerce in Sotheby's, not bring in. I also
So for the last at least 8 years, there has been a store in the village.
But did not succeed. And
After 8 years.
Yeah, but she fought the fought, and she did say that she said that she feels that a store will not succeed there. I also want to talk about the fact that there were letters written attesting to the potential owner's character. The letters didn't really talk about the need for a new store. It was just that these are good, decent people. One of the people that wrote that letter has told me that he has changed his mind and wishes he had.
Well, he didn't send us another letter.
Yeah, I know, but I'm just saying Also, I would like to address the fact that there was a letter written by a man who used his position on the board of the Chamber of Commerce. That was not allowed because this was not a Chamber of Commerce issue. But the basic issue is, do we
It's
need...
not?
Huh?
It's not a chamber issue, it's a business.
No, but we don't take a stand for or against. We're not, but so nobody should have used his position on the board because it's not something that we
Oh, I
want.
see, he did it. He signed it as a business owner, though. He said he was on the board.
Yes, but my basic point is another store is not needed. Another store is not going to serve.
Well, I mean, let me ask you this. There was a store there for 8 years that clearly is not there anymore. And during that period of time, your sales went up.
My sales went up because I worked extremely
Oh, I'm not questioning that, but obviously that store did not have a significant impact on your sales.
That's exactly the point. She wasn't doing well. She wasn't
But
doing
she was
well.
doing almost 400,000. I mean, obviously you're doing much better, but
Back to her sales started diminishing past year or so. Well, it's because it was closed.
okay, go ahead.
And so that's my bottom line, is that there's not a need for another store. It's not going to serve.
Well, there's a hotel in the village, correct?
Yes.
Is your store within walking distance of that?
No, but it's within driving distance.
Okay.
So-
Is there any store within walking distance?
No. No.
This
But-
other store was, that closed.
Yes,
Okay.
closed. So that's my point. There isn't, I don't think it's not warranted, and what it will do is severely affect the two existing stores that have worked very hard. I mean, speaking of me personally, I've worked very hard. I've done a lot in the community, and I really feel that I will be affected, which will then affect going forward, my employees going forward, the amount of contribution I do to the community.
Okay, go ahead.
My basic point is I believe there is no need for a third store. And
Oh.
I believe it's the exact opposite. We need businesses that will succeed there, that will bring tourism, that will bring commerce, that it's not going to bring any more money. It's just going to take from the existing pot that's there.
I mean, that's not really what we're supposed to, and nor is it something that we do look at. The standard is it convenient for the public? Is another store advantageous for the public? That's what we look at.
If you're asking me, I'm going to say no. I also feel
Well,
it's not convenient because I know quite a few of the delivery people have indicated the fact that it's very difficult to be on that street, to park a truck, then traffic gets backed up. And I also feel that it will affect other stores because I know personally there are times I won't go to that street because of the traffic situation. You cannot park a car there. So I feel that it will also adversely affect other businesses.
But it's also within walking distance of concentration of people in Socrates, is it not?
But there are 19,000 people living in Saugerties. They don't all live in the village. There are other, there
There's
are
some that
other
live out
parts.
by you.
Huh?
There's some that live out by you.
Right.
All right.
Thank you.
Thank
I
you.
think we have some more people in opposition.
Yeah. Morning.
Heidi Maloney,
Hi.
my daughter Maloney, who's living with two of the owners of Maloney's Wine Liquor. It's on the other side of town there. And we also sent in a letter of protest, and we just had to come here and just.
Could you just speak up because you're being recorded, and I want the people in New York to be able to hear you.
Yes.
Which store do you represent?
Maloney's Wine and Liquor in Saugerties.
Okay, all right.
We're in the other shopping plaza on the other end,
Okay.
and I believe we're within a mile of that hotel you were talking about, so we are in what I consider walking distance of that,
But we have you at 1.8 miles, which I guess you could walk.
not from the hotel.
Well, I mean, 1.8 miles from the applicant store, so it's
Oh, I'm
probably
sorry, I thought it was
further
on
than
two from the store itself.
I'm not telling you we're exactly right.
So I just wanted to piggyback on what the owner of Town and Country was saying.
But see, I have the same issue with that argument with you. as well, because in the last 3 years, your sales have gone up
Right, we just,
pretty well.
right,
And we
we
took
just,
nothing from the store for the first 2 years. My husband worked a nighttime job while I was working the hours at the store. We put every single thing.
Well, I mean, I'm sure it's expensive to run a store. I'm not questioning that, but what we look at is whether there's an increase in demand for alcohol, or whether this third store is going to significantly affect other people's sales. And it's obvious that when the third store was in existence, it didn't.
well, I'm glad to hear you say that because I heard it differently from what you said to Peg, that you don't necessarily take into account what's going to happen.
Well,
to
we
the
do
other stores.
question whether there's a higher demand for alcohol.
Right, so, in our opinion is, we're kind of maxed out. I'm not sure about the other store. I imagine after 20 years, they're probably at where they're going to go to, and especially with the steady decline that's going on in some of these. I can't.
I don't know whether you're aware, but I live in the next town.
No, I am aware of it,
And
Chairman.
I don't think anyone has ever said to me that there's a steady decline happening in Saugerties. In fact, I hear the exact opposite.
Well, we have, I mean, real estate, we have a lot more weekenders.
Exactly.
Yeah, but not.
I wouldn't call that a decline, though. I mean, I've lived in that area my entire life. I've seen Saugerties in decline, and it's not in decline right now.
Right, so my other point is that the business plan of any store trying to open in Saugerties and be successful, long-term success, other than what the other store had done, has the only people that they can be successful with are taking from the other two stores that are already serving the convenience of the local economy.
Okay, thank you. Thank you.
Well, I'm not sure.
You want to add anything? Go ahead. Anyone else?
That's all we had in opposition.
Okay.
Morning again, Mr. Chairman, Commissioner Ford. I'll just take a few quick minutes. Nick Warner, representative for Dallas Gilpin and Edward Gilpin, the applicants for Windmill Wine and Spirits. Our application speaks for itself. We did provide letters of support, not only from the village mayor, the town supervisor, police chief, local business owners, and other community stakeholders. The Gilpins very much have invested in the village of Saugerties. In the last several years, they have invested about $1 million in real estate and businesses in the village of Saugerties. They recently, in the last 3 years, opened up or renovated and reopened an existing restaurant in Saugerties, which has had no violations or no negative history. They created 30 full-time and part-time jobs through that restaurant.
What restaurant is that?
The Dutch Ale House. And they're intending to create 6 new jobs in this premises with an investment of approximately $70,000. In terms of the convenience, as the board has heard and has been discussed, the prior operator of the Partition Street Wine and Liquor initially supported this application with a letter of support, which is in front of the board. In addition, the board is aware of the sales of that business and what they were doing annually, and the current applicant intends to absorb those sales and hopefully have other business from the local traffic from areas.
So, but just let me, because there's something that's confusing me on this. No question that she initially supported the application, and it sounded like she was going to put the license, or she was going to surrender the license back in March. Or, I'm sorry, back in January. And then in March, it all changed?
From what we gather, Mr. Chairman, she was still operating some sort of an internet business. I believe the authority, through its investigators, reviewed that. I'm not sure what the outcome or determination was to that. But at the present time, it appears the license is inactive. It proposes to expire on the 30th of this month, but she has not had tenancy of her space going back to January. And in fact, there is a new occupant of that space, which is not a liquor store.
But was there a falling out between the two parties here? Or what?
Initially, what had happened was the individual you speak of was attempting to, in some way, work for the applicant. What had happened was that she had sent a solicitation email out to her customer list. The applicant asked her not to do any of that until the application was completed and approved by the authority. And that was at the time in which she was still selling wine as partition wine through internet sales. And The applicant did not want any part of that, since she did not have a physical premises. So that was what the falling out was at the time.
Okay.
If I could, I'd like to ask the applicant also just to share her thoughts with the board and answer any questions that you might have.
Sure.
So the space that was there before Partition Street Wine Shop, they had a very niche product. They weren't open. They had a very limited number of hours and a limited product. And we're seeking a completely different business model, wider variety of product, bigger hours, reaching outside of Saugerties. Agree that Saugerties has been growing. I've been having a big hand in doing that as well. And we definitely see that we're offering a very different business model than the other businesses. And that
Like what? What are you doing different than them?
we have a more elevated product line, so not just in the product, but in the service that's offered, very customized service. We won't be carrying a lot of the similar products, so
How are you customizing the service? I mean, it's a liquor store.
we'll be doing a lot of private buying for customers that we already know of and that we have, as far as selecting what they like and really offering an elevated level of personalized service, I should say.
And tastings or anything like that, or?
Yes, we'll be doing tastings on the weekends. We'll be doing collaborations with other businesses in the village.
And what's the size? I see the size of the store is 1,220 square feet, but we have a typo in ours as far as the retail space. What is
There
it?
was a correction, Mr. Chairman, sent in with the supplemental information. It's approximately 1,183 square feet of retail space for the store itself. Deputy Commissioner, did you get that on the supplemental? Yeah, it was a typo in the form, Frank.
As I say, it was a pretty small footprint. It could be the smallest store.
Outside of Manhattan, right?
Yeah. Just get a couple more questions. So the other store's been closed now since January,
That's approximately correct, sir.
And I got to believe, given the sales numbers in 2018. Before that.
Yeah, it seemed like it was going down before that. Our numbers halved between 2017 and 2018.
Yeah, the applicant just stated that she had been closed down and had sporadic hours and was only doing this curated business where she was selling to her club.
Yeah.
The physical space, she ceased occupancy in January.
Somebody else in there?
There is, yes, there's a home goods store actually brought a advertisement of theirs. They've occupied the space since February.
Chairman, just so you know, the closest store has their license in 17.
Yeah, no, I'm aware of that. That's what we're talking about. Is
But I mean, they did actually put it to safety
after,
back in March.
right, which is when they reneged on their support for this store. But there's no removal application or anything.
I just got happy with those and that's for sure.
There is nothing in the system as of this morning, when I checked.
No, and the renewal advisory was returned.
Yeah, it's a quote.
Yeah, that whole program.
You ready?
Yes.
Yeah. We're ready to vote, Mr. Secretary.
All right, then. Commissioner Ford.
The store that was there for several years is now closed. They're literally like 100 feet away from where it was. You have the support from the police chief, the mayor, town supervisor. I'll discount the one from the chamber. The original store is now occupied. No one's coming back to it apparently. So I think within the small area of the village of Saugerties, I think there was a public convenience advantage, and I would have to vote to approve to continue there.
Chairman Grab.
I'll vote to approve on the same grounds, plus of the four closest stores, 2 of them are over 8 miles away. The 2 that are in the town of Saugerties are not within the village, and both of those have shown increasing sales numbers over the last 3 years, while that other store in the village was open. So I don't expect that this new store would affect those existing stores, and I see this store is replacing the other one, so I'm going to vote to approve. Good luck.
Thank you.
The next item is 1306, Rainy Stout Inc.
Chairman Bradley, Commissioner Ford, my name is Jim Linan. I'm here this morning on behalf of Rainy Stout Inc. relative to a lengthy negotiated conditional no contest plea to plead no contest with an understanding not to exceed $30,000 in civil forfeiture and a 45-day suspension. In making that plea, we, the licensee, had advised the authority through its legal counsel that we would voluntarily add additional conditions, and we have expanded those as we have gone on. The licensee is well aware that having started as a restaurant, although their license application was for a tavern, they've always had a full menu. They've always been open for lunch and dinner, and they have operated as a restaurant, but in the last couple of years have started to undertake what they refer to as college nights, getting away from their original business model. The applicant is going to do several things, and they've already started on this road during the time that there has been a suspension in place. The applicant has committed to no more college nights, no advertising for or promoting college nights in their establishment. They will commit that all of their service employees, 100% of their service employees, will attend and complete successfully the ATAP program, or they will not be permitted to be employed. They have already purchased 2 IntelliCheck scanners. They had experience of the 8 security personnel who were on duty on the evening of the offense. 7 of them were licensed. 1 was not. That's 1 too many under the guidelines, and they acknowledge that, but they now have taken the step that the authority has recommended, that they get the IntelliCheck scanners. They have ATAP programs. In addition, the licensee will be filing an application with the authority to amend its license in several respects. First of all, they will amend to establish what they already are, a restaurant, not a tavern. They will check the appropriate box that on occasions they will be...
Hold on one second. You amend for that?
That would have to be a class change.
Yeah, that's another,
Not the,
that's a full class change application. Go ahead.
Okay. The previous applications, the box was checked that there would be no dancing. If you have people who are doing anniversary parties or whatever, somebody's going to get up and dance. In addition, one of the partners, Mr. Lawson, will be purchasing and has retained me to do the legal work, and we have started the legal work to buy out the interest of Mr. Graney, and there will be an application for an approval of a change at the Secretary of State's office, that a new DBA will be filed, and the name change of the restaurant will be Molly O'Brien's. I would ask the board to consider in our plea offer the extensive community involvement that the licensee has undertaken, as established by the various letters from charitable organizations, sheriff's departments, etc., of their participation in their community. That their employment of 25 to 30 employees generated over $430,000 in payroll during 2018, and that they produced for the local county, state, and town over $80,000 in sales tax revenue in that same time period. The licensee acknowledges that laws and regs were not properly followed. We are going to have And we will propose to the authority that it is, in our mind, a condition of our plea. A change in operation, a change in business model, and a change in ownership. We would ask the authority to take into consideration that we are now 55 days into the suspension, which has been crippling to this business and its employees. A lot of the employees, this was their full-time job, and they've been out of work. Some of them are holding on, getting part-time jobs other places, hoping that the place will reopen. We would ask the authority to consider in the civil penalty and in the suspension that the rather substantial financial penalty that they have already served be taken into account, and that some of the time served be considered in the suspension, and some of the lost revenue be considered in assessing the civil penalty. Mr. Graney and Mr. Lawson are here with me to address the board and to answer any questions that the board may have.
You guys have been licensed since 2011, right?
Yes.
The only other charges you have are 2 disorderlies. Were these on college nights by any chance? Remember?
It's hard. I can't recall, sir, to be honest with you.
Yeah. I got to tell you, I always wonder why places will have college nights when 18, 19, 20-year-olds are obviously not allowed to drink. It seems like you're setting yourself up for these kind of problems. So I give you credit.
Want me to answer that question?
No, I haven't. I'm speaking rhetorically. I know the answer.
Dollars.
Yes. Unless you're just talking about seniors, and even so. But still, I think it's in your best interest that you have come to common sense and decided not to have any nights like that. Could I have just a moment with council, please?
We're back on the record after a brief conference with council regarding item 1306.
Anything else to say, gentlemen?
No, we're be happy to answer any questions from either of you, but we are prepared.
So I don't really have any questions. I mean, I do want to make it clear that without all of these changes, we would be shutting this place. I believe you guys have other licenses, one of you?
I know, yeah.
And in here in Albany?
Yes.
What's the name of that one?
Granny's Bar and Grill's been there for 18 years.
And you know, and it seems like every time we run into these problems in Albany, we don't end up in bars with these types of issues by accident. It's because somebody's calling and telling us this is happening. And it's happened a number of times in the last 4 years that I've been here in the Albany area. And, you know, I'm giving you credit for your community involvement and for the fact that I've been in your establishment prior to any of this for a birthday party. And I know what type of establishment it is. And it's, you know, you run a clean place for the most part from what I can tell, other than these college nights. And there's a lot of colleges around here. And that is a huge issue for me because this is a driving community. And the last thing I want to be anywhere near is an underage person drunk at a place that I license. That is driving around. That just has a bad experience written all over it. So, you know, I don't have any questions. I think that I'm going to require that there be 2 scanners and you're going to call our enforcement bureau. I think the company that you have indicated you're going to buy it from is an effective company, but there are other ones out there that are, there are other ones out there. I'm not going to recommend one, but there are others out there that are effective as well. I'll leave that up to you, but there are a lot that are not effective, so you need to do research on that. I think the one you have indicated is an effective company.
One of them told me, that's why I asked them directly. Who they suggested, and that's the name they gave me.
And then the other is the no college. You're going to be the new owner, right, by yourself. The no college night is also going to be a, no college specials, nothing like that. And then I'll accept the plea as it is.
So, as far as the time of the suspension, 45 days kick in today, or on payment of the civil penalty?
No, it can kick into that.
All right. And technically, it's kind of like a counter offer, you're adding those two conditions, which you're.
Well, it is, but they volunteered those conditions, so I'm just making them part of our
We're
conditions.
just making it official, yes.
Just so, two issues, I don't mean to interrupt you.
No, go on.
They've already purchased the scanners.
Okay.
And I got an email this morning about the software is all downloaded, et cetera.
And like I said, that's a company that's widely reputable, so I wouldn't, but I'm sure they would be satisfactory to us.
And the other issue is if the board would consider or has considered giving credit for the 55 days of closure in the 45-day suspension.
I'm not, simply because I think more cases than not, we have shut people for this. There were 38 sales to minors. A few of them were under 18. And we hear the same thing from, whether it be New York City or up here, that the IDs are so advanced, you don't end up with 38 underage kids in your bar because the IDs are advanced. And there is, as I said, and you guys have probably found out, there's technology out there that is better than these IDs now. So that really is an excuse that does not hold any water anymore. So I'm not willing to shave it off now.
For the authorities' advantage, the investigation clearly revealed that some of the kids actually climbed the fence to get into the establishment, to get onto the patio and then get in the door.
So who do you want to blame that?
It's still your responsibility.
I understand that, but it wasn't that we were
I
waving
was
the
a 19 and 20-year-old at one point, and I probably would have been the guy climbing that fence. But,
A long time ago, right?
but yeah, it was a long time ago. But in today's day and age, with the social media, all they have to find out is 2 or 3 kids got in, and they're all going to be there the next night. And it's the bar owner's responsibility, one, to keep them out, and 2, if they're climbing fences, then you don't have enough security. So
I'd be willing to give you 40 days. I'll shave off 5 days for you if it's okay with the chairman.
all right, I'll do it.
Thank you.
You're welcome.
You'll plan a corporate change for that question.
Wait, yes,
No, but if it's not done after the 40 days, you can open. It's not.
okay, yes.
You'll have
We
to do
we
it
will,
all.
it's my experience right now that with corporate changes, it's taking literally months to get through the system. So we will get it filed, but we
It
will
won't
be
take.
operating.
No, it won't take months. It might take a month, but don't. But you guys can open once the suspension's over. Open as you are, and then when you do the corporate change, just do it.
40 days from today.
All right,
Okay, thank you very much.
thank you.
Next item is 1288, A.L. George LLC.
Hello.
Leonard Fogelman is here in the New York office on this also. Good morning.
Good morning, Mr. Fogelman.
Morning, Austin George from A.L. George.
How you doing?
Good.
So we have a offer of $3,500 to settle this case. We provided you with details about the corrective action that has been taken. If you have any questions, either myself or Mr. George can respond to it.
So you were doing invoicing out of Onondaga Beverage Warehouse, is that correct?
Well, no, sir.
I might be able to explain. I met with Mr. George.
Okay.
I remember explaining what happened.
All right.
They were given advice by they had a warehouse in Syracuse.
Yeah.
And we're going to get a wholesale license for that location. Instead, they may be given advice by the liquor authority not to do that. They got a warehouse permit instead, but they erroneously started billing invoices from the Syracuse location, which is not something they can sell from. So that was one of the big problems.
Yes, our invoices had, first of all, we applied for DBA Onondaga Beverage, although our company officially, legally availed, George. Our invoices are billed off the trucks and not from the warehouse. But they said Onondaga Beverage on it, and we had an improper address. Our address in Binghamton said Binghamton address, because we have two warehouses, and the one from Syracuse had a Syracuse address. So we weren't in compliance having the proper name, because although we did a DBA as Onondaga Beverage, we didn't notify the State Liquor Authority of that.
So now the corporate name is on all the invoices. The DBA has been added properly onto all the licenses. The liquor license number will be on all the invoices. So the invoices should be in proper order from going forward.
Okay. So everything is in order at this point?
Yes, sir. And we forwarded that to the State Liquor Authority and showed them where we made those changes to our invoices. And we also notified the State Liquor Authority that we're using the name Onondaga Beverage in 2 counties north of Binghamton.
As a DBA?
Yes.
Okay, all right. I'm willing to accept the $3,500.
I'll accept it.
Thank you very much.
Thank you. Thank you very much.
Next item, 1233, Casa Tacos Corp.
State
Good morning.
your name on the record.
Yes, good morning. Stacy Weiss, the applicant.
Hi.
And I have here the landlord, Mr. Tom Director, and the property manager, George. What's last name?
Thitherides.
Did you say it?
George Thitherides.
And the applicant. Introduce yourself.
Ioannis Solomidis.
Yes, this is a reconsideration for Casa Tacos Corporation, which is located.
No, it's not. It's an application.
I'm sorry?
It's an application. It's not a reconsideration, from my understanding.
No, that it was approved erroneously.
It was a.
Oh, I see. You got a temporary permit and it was taken away. I get it. Okay.
But this is deferred. This is not a reconsideration of the application.
It was a reconsideration for the. It was we did a reconsideration for it because the temporary was taken away.
Twice.
Okay, it's an app. Okay.
Twice. It's before the members today.
Okay.
It's a consideration of the license application. There's
Okay.
nothing to the members right now about reconsidering the denial of the temporary permit.
Okay. Well, all right. Well, this application was. I'm asking for that the stop be vacated during the period that the licensee had a. Well, okay. Then let me start over again. We're asking that the stop be vacated from the location. The applicant had nothing to do with the prior application with the prior licensee. He did not purchase the license. He came into the location from I'm sorry. Let me start over again. I'm very sorry. The applicant is leasing the place from the landlord here. The landlord had no knowledge of any problem that occurred under the prior licensee. the location.
Twice?
Yes.
Are there copies of the pleadings?
I'm sorry?
No, I find that hard to believe.
No, well, let me tell you what happened. During the period of the problem,
I know what happened because I licensed it twice and closed it twice.
Okay, let me just tell you what happened. The license was under the licensee who had the place before was under the control of Silverman Properties that held a 20-year lease. Had a 20-year lease from Mr. Director. They leased it from him, and they sublet it to Mamaroneck Smith, the licensee. And what happened was the notices went to Silverman Properties. He was never notified. Mr. Director was never notified of any problems that occurred. And now the Silverman Properties no longer control it. They left the location, and now we have WFL is now the controlling what do you call it management company. I'm going to let Mr. Director tell you what happened. He no longer leases it to that company Silverman. They no longer control it.
All right. I don't want to hear from him what happened. I want to know what is going to happen.
What's going to happen is, and I'm going to let Mr. The current applicant tell you what he's doing there. But it's no longer a company that runs it as a bar. He's running it as a family restaurant. He has 25 employees, and he's running it strictly as a family restaurant. He has a full menu. He has a full kitchen. He has a chef, and he's running it with no problems in the past 3 months. And I'm going to let him tell you his story. Go ahead, John. Tell your story.
Thank you very much. I've had a liquor license for the last 14 years in another location.
What location?
It's in Astoria, Queens. It's called Grand Cafe, the Grand. We were looking for a new location, and my partner has another location of his own in Harlem, and also he has a clean record as well. We looked for a new location. We found a space in White Plains. There was a sign out for rent. We wanted to hire someone local since we didn't know the area well, so we hired someone a couple buildings away from there who was a liquor attorney. He said he could, we applied for a temporary, we were approved, and then we further on invested, and we hired 25 people. We've been open for 3 months, 3 months with no incidents. We close at midnight. The latest, the community and families have supported us. Nothing like the previous business at all, which was a bar, a full bar. We're adding the value and the jobs to the neighborhood. And this is my full-time job now. I've left my other location. I'm there full-time. I'm being responsible every single day to make sure, because there are other bars in the neighborhood, so I make sure that we're making sure that we're showing everyone that we are a restaurant.
Would you continue to close at midnight if you had a liquor license?
Absolutely. Absolutely. Doesn't affect our business at all. Lawyer said, when we originally hired our first lawyer, he said it was okay. We were approved for temp. We hired staff. We were open for...
Yeah, that was on our... Well, I mean, part of that was our, part of it was yours.
Yeah.
Because you guys were giving us the wrong address as the location, which I don't know how that happened. Adam, do you know how that happened?
No, I'm looking into it right now. I could explain
and then,
what we found out after, yeah.
Well, go ahead.
When we rented the space and we received the lease, our original lease was 166A, but we didn't realize that I believe it wasn't under the municipality yet from the landlord, but that was unbeknownst to us.
And then you didn't indicate on the questionnaire that you owned another company, Tria Realty?
Tria Realty is my company that I invested money from.
Invested what money from?
My money to invest into this business.
No, but it's obvious. Is that a business itself, Tria Realty?
No, it's an account. It's a bank account that I opened at some point to I was supposed to buy something and I didn't.
And then you didn't indicate you were married.
Oh, yeah, I'm married.
I'm sure your wife will be happy about that.
Yeah.
Can't help you there.
But yeah.
She's not licensed anywhere.
This picture, stadium, is this the location?
Yes, absolutely.
Hey, remember this place, the one that came in and told us she didn't have a relationship with the former owner?
Oh, yes.
They had a relationship.
Yes.
And we had to close it?
Yes. Now I just do this one.
Are you going to periodically close to host private events at all?
Possibly. I mean, we have an upstairs room, but we haven't used it yet.
Are you going to use event promoters?
No, absolutely not. We don't need that.
And the hours of operation, you're going to close at 12 every night?
Yeah, I mean, the latest we've stayed open is 12:30, 12:45 the latest. And that's on Saturdays, just because we have a late night menu. But Monday through Friday, we stay open till 11.
Well, what's the DJ for if it's a family restaurant?
Just for events. We don't have a DJ right now.
It's just for if you were to have
Just if we were to have an event, yeah. We really don't want to even go in that world.
And what's the security? You have security
We
security
have-
every night?
We have one security that we bring on Friday, Saturdays, just because we know the neighborhood from what we've learned, and we want to make sure that we're doing it right, and we have someone at the door. And when the security's not there, I'm at the door.
Okay. So have you listed the top floor as part of the license area?
Yeah, we have put it in the application, but we haven't even opened it yet.
But it's officially on your application.
Yes.
So if
Yes.
you want to use it, you can.
Yes, correct. Yeah. We've just been open for a few months, so we haven't even got into our catering menu.
I'm ready to
Ready to vote?
Yes.
Commissioner Ford.
I'll vote to approve under the one security guard on Friday and Saturdays.
Yes.
Close at midnight during the week. I'll give you to 1 o'clock on Fridays and Saturdays. You know, so they can handle any stragglers getting out after that. So, this place had a bad history, so you understand our concern about it, especially when the previous person came in and lied to us about it. So, I'll approve on those terms.
I'll approve on the same terms, plus no promoters. What did you say, one?
Well, it's midnight Sunday through Thursday and 1 o'clock on Friday and Saturday.
So no promoters and no dancing. And then I'll do the same hour.
We'll allow you to DJ too.
Now, and as he pointed out, this place was, and I don't know if you've seen the history, but if you haven't, you should probably get it.
I did, as we opened, people were telling me the...
So, and you should look, because it's multiple pages, and I don't even need to see paper. If somebody just tells me the address, I know it. That's how bad it was. So I would, keep it in line, because it was very bad for the neighborhood previously, and if it gets bad again, you're gonna get a short leash.
No, absolutely. We're 3 months we've been everything. We haven't even had a call or an incident even close.
All right.
Commissioner Ford, would you able to no dancing, no promoters?
Dancing, no promoters, and like I said, I will allow you even a DJ.
Yeah, the DJ.
Yeah, it's on that.
Yeah, we our other location, we have a DJ just for dinner, just to have a little bit of ambiance music. And
Exactly.
We
That's
don't
what
do
I'm
it. Yeah.
Not a mosh pit.
No, not at all.
All right, you're all set.
Thank you so much.
Next item on 1325, Loyal Temple number 148, IDPOE of West Elks, Inc. You're here for this?
Yes.
Anybody else here for this matter?
I thought you ladies would be familiar.
13.
Yeah.
1325.
I think we asked you to go to the Albany PD. Is that what happened? We asked you to come back and just back to the Albany PD?
Yes, I am.
I can tell by your badge.
How are you doing?
Can everyone state your name for the record, please?
Jason Wilson, the detective with the Albany Police Department.
All right. Most people just bring a letter.
We asked for a letter.
Right. They said
They said they were gonna send somebody, so.
No, they're nearby. Yeah.
Yes, we are very close.
So what do you got to say?
So we were looking into the application. We met with a representative of Bill Temple and Ms. Sharon Guy. Upon speaking with Ms. Guy, it was a good conversation. We asked her to provide us with some additional information as far as the members for this Elks Club. I believe the kind of license that we're looking to get is going to be a license that is for private events. We didn't really have a major concern with that, but we want to know that the business plan was going to be as far as whether or not they're going to have security in place, and it's going to be like a private event, whether or not there's going to be a guest list, and you have to be on that guest list in order to attend that event. Because we have had an issue before in the past with banquet halls, where it's a private event, you're supposed to have a guest list, and then there was an incident that happened there where the actual guest list was a combination of real names, Facebook names, and email addresses. So we couldn't really verify who was there and who wasn't there. So that's what we really want to know as far as like those things, as far as like the business plan for us to really be able to give an informed decision.
Okay. So you met with them and you're comfortable at this point?
We met with them. I was looking to meet with her again. Unfortunately, we weren't able to do that. So at this point, I really don't know for sure. I can't say one way or the other. I mean, I believe that we do want to do the right thing, but we just don't have all the information at this time.
Now, you're opening a club. You realize that, right?
Yes.
So it's only for members.
It's for members and their guests.
And how many guests can a member bring in?
We have not established how many members can bring in, but the place only holds between 50 and 75.
Well, I think the detective will tell you that hasn't stopped people from trying to put 150 in a place that only holds 50.
Yeah.
I know the problems he's talking about because we had to deal with them too in Albany here, and it resulted in people getting hurt. And that's what I think he's trying to avoid, and that's what our concern is as well. If you're attempting to open this to have parties, it's going to be a short term. If you're opening it because you want to open a club for members to go and socialize with each other, which is what you're telling us you're going to do.
That's our main purpose.
Yes.
I want it to be basically your main purpose, but the biggest purpose. The private parties should be minimal.
Yes.
And the guests should be minimal. And we will hear from them very quickly if people are walking in with 10 and 15 guests. Because that's not what this license is for, that's not what these businesses are for.
Okay.
You only have 27 members,
Right.
and your capacity is only like, what, 50 to 75?
Yes.
So, are you trying to recruit more members than 27? It's a pretty small membership.
We do recruit more members, yes. But we only have a certain amount of space.
Yeah. So the more members you have, the less guests.
So less guests, right.
I mean, do you have serious concerns about this?
The only thing is, like I said, last time we had a situation that was similar to this, as far as like being able to get a guest list and not being able to get that guest list. You know, we did, like I said, it was a combination of Facebook names, email addresses, and some real names. And then as far as like security as well, because obviously that's real big. We want to make sure that there is going to be any kind of event there. We'd like to know who the security is going to be there for those types of events.
You really shouldn't even be having the kind of events there that you need security for. I mean,
Right.
it's the freaking Elks Club.
Yes, right.
All right.
You ready to vote?
Yeah. I will vote to approve. If you do have something going on, you need to have a legitimate guest list, not Facebook names, not Mickey Mouse, whatever.
Okay.
Real legitimate guest
Names
list.
and addresses.
For private, for events.
Or no, any guest that comes in.
Any guest.
Yes.
Any guest, the guest list should have names and addresses. That when they sign in.
Okay.
And they have to be with a member.
Yes.
They're not, it's not somebody sitting at the bar and a guest wants to come in. Oh, I don't know you, but you can be my guest. They come in with the member.
Okay.
And we do check.
All right.
And I think detective will check too every now and
Yes, as long as we're able to, I mean, we just want to be transparent, you know what I mean? Because we know that there's no 100% way to avoid, sometimes incidents are going to happen.
Yeah.
But it's beneficial to us, and I think to them as well, if we know exactly who was in there, and we can resolve that issue if we knew who exactly was in the establishment at that time.
And then I am gonna, if there is an event that you're having at the establishment, you're to have a licensed security guard.
Yes.
Yes.
And events can only be held by members.
Yes.
Right.
You can't hire a place out.
No.
No use of promoters.
No.
Are you gonna? Would you think you'd have any type of events that require dancing or anything like that? I'm asking
Well,
now.
they may have a birthday party or you know, I plan on having my birthday party there. I'm old, but
Start
I dance.
All the more reason to have a birthday party. You know, I'm not going to allow dancing for now. Let's give you a year and see how things go.
Okay.
All right?
All right.
If that's okay with the chairman.
Yeah.
Yeah. Okay?
Okay.
Good
All
luck.
set? All right, you're all set.
All right.
And I would
Thank you.
suggest you take his card and you give him phone numbers. So
Yes,
that
I
he,
will,
Okay.
I'll
Okay.
give
All
that
right.
out on the change.
Okay.
and the best thing, I'm not going to require you to do this, but the best thing you can do is if you're having an event, let them know you're having one.
Okay. All right.
Thank you.
Thank you.
All right, we are done with items signed in Albany. We have nothing in Buffalo. Michelle, you can go ahead and sign off. And we will proceed to New York. And the first item there is 1307, and also we want to pull out 1308. Those are two delegations of power, one with respect to the price posting, and one with respect to the COD list.
Good morning, Commissioner Ford. Good morning, Chairman.
Good morning, Mr.
Kevin Dano for Empire Merchants North.
It's Mark Coslow from Buckland Law Firm. I'm not representing any client directly, but I have numerous clients that will be affected by the delegation of authority, so it's important to my client base.
Okay.
So first we would ask that with regard to 1307, that the delegation include the acting counsel and that the acting counsel be permitted to delegate to senior staff attorneys as he or she sees fit.
Okay.
This is important to us because what happens here is when a new item comes into the marketplace, if we can't get this right, what happens is we'd have to go to the full board. The full board could be a month or two before we could get to the full board, which means that we don't get this relief at all. This happens when there's a new item. It happens when there's an agreement between an outgoing wholesaler and an incoming wholesaler, so that they're going to change who's going to be handling it, and with a whole bunch of rules that include the outgoing wholesalers having his inventory purchased by the incoming wholesaler or the supplier. There's usually an agreement that says that they can adopt the price postings. It also happens when there is an issue by an outgoing wholesaler that his inventory wasn't purchased, and if they don't get permission, they'd have to stop selling it and drink whatever's left over. So the Liquor Authority routinely, these are all routine is what I'm trying to say. And the final one is when the outgoing wholesaler, when the outgoing is not selling the product and emergency relief is required to make sure that the product stays on the shelves during the transition phase. These are all fairly routine except for the last one, in which case you'd have to really show that the outgoing wholesaler was not actively selling the product. But if we don't have delegation, there'd be a serious problem because of the time that it takes to get before the full board. So we ask that you approve this.
Chairman, I don't think you need to reference acting counsel. Mr. Furry, as the acting counsel, has the power of the council.
But this is only on to take comment today, right?
No, this is for you to sign off on.
Oh, okay.
And the other thing is, I don't necessarily think you need to reference the other attorneys and the staff. I mean, the council will have the power if it refers to certain attorneys and the staff. Ultimately, though, it's signed off by the council.
If that's the case, that's fine. That's fine with us. The only real problem is that I noted that in some of the other delegations, you do have that language included.
That's the prosecutions where individual prosecutors are prosecuting cases.
But I don't have a problem. I don't think we need to put in the delegated staff attorneys because obviously I think you can do that. But I don't have a problem putting in counsel or acting counsel since we do have an acting counsel right now. It seems that we have had one frequently over the last 3 or 4 years.
How's that, counsel or acting counsel?
Okay, that fine, right?
Yeah, it's fine. Just to make sure I understand, what Keevan was mentioning was the third bullet point on the delegation of power form, which refers to allow a wholesaler not designated by the brand owner as an authorized distributor of a liquor or wine to file a schedule of prices to sell such liquor or wine to retailers. We just want to make sure it covers all those instances that he mentioned, because those are the routine matters that come before the basically council and other staff members of the council's office. They come up actually more than several times a month. You have new items coming on, the new wholesalers come into being, you've given them a license, and they can't file their schedule timely. It's just not possible. So unless you get the authorization from the agency, without having to go to the full board all over again, it's
Mr. Kozloff,
the problem, that's all. Yeah.
The delegation covers all the powers under the price posting section that the authority has.
Okay.
So they're all being delegated to council.
Then
So
we are content.
Then we're fine.
Okay, yeah. So what you're talking about is covered. Yes.
Okay, thank you very much. Can we turn to 1308, please?
Well, we'll vote on this now. So.
Oh, I'm sorry.
So I'm fine with the delegation of power, except just adding to the powers of council, delegate the following powers to the council, to the authority, or acting council to the authority.
Same here.
Thank you. Now, can we turn to 1308, please?
Yes.
Okay. Again, with regard to 1308, we ask that you add acting counsel. And then I just would like to make sure that you understand that this delegation may be a little broader than you wish. In the past, we have come to you repeatedly, and it has become routine, to make adjustments to the delivery schedule with regard to year-end and with regard to shutdown. But the particular delegation that you're giving includes all powers, and I would point out to you, so that you make sure that you understand what you're delegating, that it also includes adjustments to the credit schedule. And in the past, sometimes you have agreed to adjustments to the credit schedule, and other times you have not. And it depends on the particular circumstances, and that is not routine. And I would also point out to you that in every case where that happens, there's plenty of time in advance for it to go before the full board. Just to give you the best example, the last time that we asked for a shutdown adjustment, we asked for a shutdown adjustment both to the delivery schedule and to the credit schedule, and the full board approved the delivery schedule change but refused the credit schedule change. So that was 2 years ago. So you may not want...
I understand what you're saying, but on all of those occasions, at least since I've been here, those are issues that have been discussed internally with council, myself, the executive deputy, Tom, so that we have enough communication here that I'm comfortable giving that power to the council, because I know that it will be a agency decision as a whole.
Okay, just as long...
Mr. Daniel, council defer and send the matter to the full board.
We understand
Just as
that.
long as you have considered what you're doing, whatever you do is fine with us. It just want to make sure you knew about it.
I mean, it just gives them the power to act quickly and certainly take things off of the full board, which, as you can tell, is frequently overwhelming as it is.
Okay.
All right.
And thank
so
you very much for your.
I'll vote to make the change, the following powers to the council or acting council to the authority, and then leave it as it is.
Pretty much same as 1307.
Yes.
Yes.
I'll set that. Okay.
Thank you very much.
Thank you.
Next items, 1300, 1301, 1302. Good Vision Taste, Inc.
Good morning, Stacy Weiss, the licensee. This is a CNC for $17,500. This is a combination, combined all the cases. Worked it out with Mr. Amarato. Civil penalty.
Why did they change the trade name? I mean, they already paid $1,500 on that. Now they're paying more money for the same stupid mistake.
Yeah, they put in an application for the change of trade name. I didn't get the application back from them yet. I'll have it back this afternoon.
Well, they did it twice.
They applied for a new trade name. I didn't get the paperwork yet. I was supposed to get it yesterday. They did put a new trade name. I don't know. They did put a new trade name in though.
Well, if they're
yeah, they did. They did put. They applied for it. They're supposed to send me the paperwork yesterday. I didn't get it back from them yet. That was the only violation they had.
They haven't applied for it yet.
Yeah, well, they did put it in, and it's the only violation they had in 6 years was the trade name before. Besides the new ones they got recently, but they had one past violation.
And if I get done here today and go onto my computer and look them up, am I going to find out that they're advertising a DJ?
Not that I know of.
Well,
I can't answer that. I really don't know.
Well, I'm going to go check, so they better not be. All right, I'll accept.
Thank you.
I'll accept as well, 17.5.
Thank you.
Next item is 13 Teddy Diner Corp.
Stacy Weiss for the licensee. This is a CNC civil penalty for $7,500. God bless you.
I'll accept.
Accept.
Thank you very much.
Next item, 1278, Campesinos Lounge, LLC.
Good morning, members. Thank you for your time this morning. Also wanted to congratulate you on the reappointment. You're welcome. My name is Sandra Olaya from Team COL Group. I'm here with Mr. Perez, the applicant for Papacitos Lounge. We have the main purpose we're here is to speak about the hours of operation that the community board has suggested. And my applicant just feels that for his method of operation, he's going to be limited in his premise. Mr. Perez is a big community advocate. He works closely with the Advocacy Center of Queens Community, Latino Commission on AIDS, the Hispanic AIDS Program, Harlem United. One of the things that his premise is offering to the local community is offering his space for events. So his hours of operation would start at 4 p.m. To 4 a.m.
And see, here's the problem.
Yes.
And the community board, one, it's a 500-foot case. Two, the community board imposed those hours because, and only because, of what happened the last time they agreed to license the place. And I don't know, are you familiar with the history of the former owner?
Somewhat, and just to
Well, I would suggest that you get familiar with it and show it to your client because it was a very bad place. They paid,
Okay.
they paid 25. They paid $25,000 in fines, and then were canceled in February of this year for violations that they sustained.
Okay.
And the violations were violations that affect the community.
I understand that.
Unlicensed cabaret, sales to intoxicated people on half a dozen occasions. So, I mean, I think what the community board is saying, and I tend to agree with them, is that they need this applicant to prove himself a little bit before they're willing to go out on the same limb that they were before, because it's a lot harder to get someone out of a bar than it is to try to control the behavior before we put them in it.
I completely understand that, but just in all fairness to my client has had over 20 years of experience in the nightlife industry. Aside from that, he has nothing to do with the previous licensee or the premise. That location in itself has been not only completely renovated, the neighbors on the same block opened a beautiful cafe. They're right above the overpass. There's not a lot. I understand the previous history of this premise. Luckily, he didn't, sign a lease in a premise that was, completely, violated with the 2-year probation period. But again, I understand the community board, but just, I feel like everybody should be given it, a different opportunity. Not only that, though, but
they're not saying they're not going to give them an opportunity. They're saying we're going to limit. They're not going to open the gates completely wide. And at this point, no one's saying that they can't come back and ask for more hours later.
Again, I mean, based on his method of operation, he opened up his premise, to all these communities for the earlier hours of the day, for the community. And I would like for him to be on the record as well, just to share a little more about his method of operation, so you would be more open to giving him extended hours.
Hi, Council. So basically, I'm working very hard with the community. I am not running the same establishment that they had. I am aware of the problems they had. I'm running a gay establishment. I'm working with the LGBT community, the neighborhood, which is the second biggest community out of the village, is in Jackson Heights and Woodside. The reason I need the extra hours is to serve the people that come out of restaurants that work in the service industry. They come out at 1, 2 in the morning and they want to have a beer and a burger and food at that time. I would not be able to survive if we close at 12 o'clock. It's just almost impossible. I mean, I need those extra hours to be able to pay my staff, be able to pay the bills. I got all my life savings into this place. And if I was aware that I was going to be limited to 12, I would have never invested all my money into this place. I am not asking for 4 in the morning all across. I just need at least the weekends, which I think is only fair, considering I'm the 5th gay bar in the neighborhood. They all go to 4 in the morning. I'm the only one with a full kitchen, which I'll be serving to 4 in the morning if I'm able to. I'm not asking, give me 4 in the morning every day. I understand Monday, Tuesday, Wednesday are days people are getting up early. I would love to go home early at that time too. But if you could at least consider Thursday, Friday, Saturdays, and maybe Sunday till 2, and then Thursday, Friday, and Saturday till 4, I would so much appreciate it, and it will give me a chance to provide for my family. I do have a son that's 2 years old. I have to provide. I'm using all my life savings for this. I've been working 22 years. I have my friend, he's a retired sergeant. Louis, he could testify for me. I have helped with his establishments. So, you want? I don't know if you want to.
If I can say a word, I do have 3 liquor licenses with the SLA at 3 different locations. I never had a problem. Mr. Perez has helped me overcome obstacles in terms of a business and how to run the business, how to create the most out of my. They're restaurants with a liquor license. They're not clubs. They're not bars. They're not lounges. They're restaurants. We serve food, and he took what I have in my places, and he took that to this location. He was not aware of the prior instances of this location until after he signed the lease, and it was like a bombshell thrown upon him because he applied for a 90-day temp, and it got denied.
How did you find out about the place to begin with?
Oh, he just saw it for rent, I assume.
Yeah, a broker put in the ad in the paper that it was being sold.
And the landlords didn't advise him that the operators of the previous location had these violations, and the inadequacy of his previous lawyer didn't find out because it was the time they were issued, the time he did the signing of the lease, they didn't show up on the SLA board. It was like an overlap, and he got denied for his 90-day permit to transfer the liquor license from the existing location to him, and he did a new app. It got approved, and he's not opening up one of those. From my experience as a law enforcement officer, one of those. Give me $5, I'll dance with you, I'll buy you a Corona, and you put $20 in the girl's pocket, and everybody has a good time, and everybody gets drunk and mad because, 2 guys are dancing with the same girl. He's opening a restaurant. It's for the LGBT community, and he has all these affiliations. He could prove it. He could show it that he's done functions and events for these locations. He could give you names of these people, and he's going to be an asset to the neighbors. He's going to change the demographics, the genre of what's going on Roosevelt Avenue. It'll be a sit-down place. It'll be a place where people come have a good time. And like he said, the persons that frequent those kind of locations, they do work in the nightlife industry, and they get out at 1, 2 o'clock because their place is closed. They're actors on Broadway. They work in theater. They work in Manhattan. And they come home to Jackson Heights where they live, or Roosevelt or Woodside, and they want to go have something to eat because a lot of places you don't want to eat where you work. For example, I don't.
All right, thank you.
Aside from that, if you don't mind,
Go ahead.
adding, Mr. Perez is also a certified bartender. He's done the ATAP program. One of the things that he mandates from all his staff is that they're all ATAP, certified.
Listen. This is not about him. He's clearly a good applicant. That's not what we're saying.
Thank you.
Thank you.
We are required to listen to the community board to a certain extent.
Of course.
Because it's a 500-foot case. There was some serious stuff in the past here, and that's why they're asking you to control the hours. I'm not saying we're going to do exactly what they said, but we do have to take it into account. And this is also an area that particularly Roosevelt Avenue, that we have an enormous amount of complaints coming about. So we do have to, take that into consideration as well when we're licensing new establishments at places that have been the scene of significant violations. So,
right.
But I think we have enough information.
Yes. I'm going to approve at closing hours of 2 a.m. across the board, and I would say you can come back even in 6 months and let us take a look at it and see how it goes, and we can make another decision if we want to extend it to 4 a.m. on weekends for you at that point. But I'll give you 2 a.m. across the board.
Okay, thank you.
So I'll do the same thing, but no DJs, no use of promoters, no live music. Recorded background music only. Are you going to have security?
Yes.
We do.
When?
Every day.
Do you know how many?
There's
Every
at
night.
least one security guard per night, 2 on the weekends.
Yeah.
So up to 2 security guards.
It's a small place. So.
And then you can come back in 6 months, like you said.
Thank you.
If you don't mind.
So what I would do is file that thing after 3 months, so you're here in 6 months or whatever, 4 months, whatever the case may
You
be.
want this coming back to the board, right?
Yes.
Yes.
Are you okay with all those other
Yes.
conditions?
Yes.
Thank you.
If you don't mind me asking, do you think that I could, because he already submitted all his conditional approval docs, Can we pick up this license today? The premise is ready to operate?
That's up to our licensing bureau to Commissioner Ford's left. I mean, right.
Okay. Yeah, just as long as.
Stage right.
Yes.
Okay. Thank you.
Thank you. Thank you.
All your conditions are in?
Come again, I'm sorry? Sorry, I didn't hear that.
All your conditions were in?
Based on the attorney and record, yes.
Okay.
Well, just double check. Go to the window and make sure, and then if they are, they'll give you the license. If they aren't, they'll tell you.
Okay, thank you so much.
Next item, 1214, for the Book of Venera LLC.
Good morning, Donald Bernstein on behalf of the licensee. This is an application we had filed for approval of alterations, the main component of which was to add an outdoor terrace. My client advised me late yesterday, and I advised the Secretary's office that they are withdrawing that portion of the application. That was the issue that the Community Board had an objection with, and some of the local residents did as well. The alteration application, therefore, is limited to reducing by just barely over 10% the seating in the indoor portion of the space. That's all that's left with the application.
Is the Community Board still there, or have they given up?
Mr. Booth is here.
Does he want to talk about you decreasing the seating?
No, he says no.
He's okay with that?
Are you okay with that?
As long as the outdoor area.
Yes, as long as the outdoor area is withdrawn, which it is, and I will send a formal letter amending that application.
All right, so I'll grant the decrease in seating. I'm sure they're very happy about that. And then we'll withdraw the other one.
Yep. Okay, thank you.
Thank you.
Next item, 1234, Queens Boulevard Spirits, Inc.
Good morning. Francis Buscemi for the applicant. With me today is Mr. Yee and Miss Yee. I believe there's some opposition. I don't know whether you'd like to hear from the opposition first.
Yes, please.
Hi, my name is Manly from Grand Wine and Liquor Store. It's near by the Queens. We are at 8510 Grand Avenue. It's very nearby the what they try to reopen a new store. It's just only 5 minutes of driving and 11 minutes of work. So it's very nearby here.
Okay. Go ahead.
Excuse me, gentlemen, if I may help her out, because I'm here for moral support and because English is not her first language.
Yeah.
Sure.
Okay.
Can you put your name on the record?
No, I haven't, because I didn't know I was going to be speaking.
No. Can you put your name on the record?
Oh, yes, I will, if you want. Okay. First name Edward, second name Sokol, Sokol. And I'm a previous owner of the business. I started there as a stock boy in 1969, and I sold the business in 2013. We're basically a neighborhood store, and in the times that I've been there, between managing and owning the store, probably within a good 15-minute walk, there's probably been I would have to say maybe about 7 or 8 more stores that have opened up, if not more. 3 or 4 of my previous customers had tried to open up stores within a half mile of my store. 3 of them had gone out of business. And where the new gentleman wants to open up the store, I believe right across the street is a non-denominational church. I don't know whether the SLA rules about footage close to a church still applies. I've been out of the business for 6 years now. And I believe near the same building where they are, which has just been put up for auction, if I'm not mistaken, there's a kindergarten there. When I go for my walks in the morning, when I walk by, because of all the scaffolding, I see homeless people hanging out there in the morning, so I don't know how that's going to reverberate in the neighborhood. And now May's lawyer is here, so if you don't mind that she could talk to you. I appreciate you listening to me.
All right, thank you.
Okay. Good morning, gentlemen. My name is Ziki Liu. I'm here to oppose the proposed liquor store license. I represent Grant Wines and Liquors, Inc. Here with me is Miss Man Ling, who is the president of this Grant Wines and Liquors, Inc. May I start?
Go ahead.
Okay, thank you. First and foremost, this proposed new location, which is 89-28B Queens Boulevard, Elmhurst, New York, 11373, is statutorily eligible for a liquor store license because there is a church within 200 feet, the Rock Church. The Rock Church located at 5702 Hoffman Drive, Elmhurst, New York, 11373, so which is right next to the proposed new store. It is less than 200 feet away, so apparently it is statutorily eligible. And secondly, the public convenience and advantage will not be served by licensing a new store as applied by the applicant. There are already 7 existing liquor stores within 3,000 feet radius. The closest liquor store, which is the Queens Liquors, Inc., is only about 1,200 feet away. In the proximate report for this location, which is submitted to the board in our opposition letter dated May 14, 2019, where you can find the name and the location of these 7 liquor stores. Apparently, the proximity is saturated with liquor stores, so the public convenience and advantage will not be served by licensing such a new store.
Thank you.
I have one more point to make, so
Okay.
may I proceed? Okay,
Go
thank you.
ahead.
So the sales figures of the opponent, the Grant Wines and Liquors, Inc., is also stagnant for the last 2 years. Its gross sales for the year of 2017 was about $3,278,000, and for the year of 2018 was about $3,312,000, despite for marketing and promotional efforts. In addition, Ms. Lin here, our client spent over $538,000 to purchase her liquor store in the year of 2015, and ever since she invested much more to improve her business. She has not been able to recoup her entire investment despite of her tireless hard work and 100% devotion. So with a new liquor store in this close proximity, it is not only unfair to our client who spent such a fortune to purchase an existing liquor store, but also dramatically negatively impact her business and discourage future investors to purchase these existing liquor stores. So based on the foregoing, we respectfully submitted our opposition and hope you to fully consider this matter. Thank you.
Thank you.
Okay, that's it. Thanks.
Is there anyone else?
No.
Okay, go ahead.
Yes, thank you. First, I just want to address, to get out of the way, the issue of this Rock Church. And I put it in my papers to you as well. Yeah, here it is. They're saying it's within 200 feet. First of all, it's not within 200 feet. I did a laser measurement of it. It's 300 feet. That's number one. Number two, it's on Hoffman Drive. Technically, it's not even on Queens Boulevard. It's 5702 Hoffman Drive. It corners on Hoffman Drive and 57th Avenue. So, one, it's not within 200 feet. And number two, it's not located on the same street or avenue. Having said that, I'd like to get to...
Yeah, this is it. Okay, go ahead.
Okay. All right, so the applicant desires to open up a retail store at 8925B Queens Boulevard in Elmhurst. The total size of the store is 875 square feet. There would be 540 feet of retail selling space, and the balance would be devoted to storage.
Go ahead.
So again, it's an 875 square foot total with 540 square feet devoted to retail space, the balance to storage. The store is located on the westbound side of Queens Boulevard, which we all know is a major thoroughfare. Queens Boulevard runs northwest to southwest across approximately through Queens, starts in Long Island City at the Queensboro Bridge, and then it runs through the neighborhoods of Sunnyside, Woodside, Elmhurst, Rego Park, Forest Hills, Kew Gardens, and Briarwood. It's 7.5 miles long, one of the longest and largest roads in Queens, much of the road being 12 lanes in some points. And it runs through the busiest areas of Queens. It actually forms a part of Route 25, which is a New York State thoroughfare, which extends over 105 miles from Midtown Manhattan to Orient Point. The store is located in a major shopping hub. On one side, we have Target, and on the other side of us, we have the Queens Center Mall in the building and you can see the location, the aerial view, which is Exhibit A, which I provided, showing the location of the store, the site of the store, which, if you'd see, it says site, S-I-T-E, with an arrow pointing to the location of the store. On one side, as I said, we have Target, Best Buy, and DSW. On the other side of us, on the same side of Queens Boulevard, we have Macy's and the Queens Center Mall. So it's an extremely busy area. As we all know, Target has a very large supermarket, grocery department. So along with that, those businesses have parking garage, large parking garage for parking. So there's a public convenience and advantage for food shopping and alcoholic beverages. When we look at the demographics, within 0.6 of a mile, the population for 2018 was over 72,000 people. When you get to 1 mile, the population is almost 200,000 people. Also, within that 0.6 of a mile, over 57% of the population is Asian. We feel that the existing stores are not doing a good job in catering to that demographic, which we want to cater to. And those statistics are included in the demographic survey, which I've attached to my papers as Exhibit B, showing the breakdown by race of the population. There's also been substantial residential development. I've given you a list of buildings. I've also attached photographs of those as Exhibit C. You've got a building with 184 dwelling units, another 127, another 33, another 144, another 83, and the last at 31 dwelling units. As I said, since the Asian population is over 57% of the total population in that area, we intend on carrying an extensive selection of Chinese, Korean, and Japanese products. The applicant also intends on carrying a suitable selection of New York State products, since they're either so limited in the other close stores or non-existent. Both the principals have experience in business. Ms. Yi has been working in the liquor store for 4 years, and Mr. Yi owns a restaurant in New Jersey. They both intend to devote time. Ms. Yi is going to devote her full time, approximately 60 hours a week, to the management of this store. And Mr. Yi, since his wife is involved in the management of the New Jersey restaurant, will be able to devote about 30 hours a week to the operation of the store. Now, none of the closest liquor stores to the applicant is located on Queens Boulevard. I did make a FOIL Act request. I will say that the only information that I received was on Grant, as far as sales numbers, was on Grant and Spade. And as was indicated, Grant Wine and Liquors is a 3,000 square foot store. It's about 8/10 of a mile drive. Shortest driving distance is 8/10 of a mile from the applicant. Its sales in 2018 were over $3.3 million. And the sales have shown increases each year. Niroji is a 1,000 square foot store. Again, its sales are trending upwards. It carries a very limited selection of Asian products. I provided you with an Exhibit D, which shows you the products that they're carrying, which is not that extensive, and it doesn't carry any New York State products at all. Also, you can see from the photograph, the store is not, it's poorly stocked. A lot of empty shelf space.
We didn't get a response from Costlow Wines and Liquors. Ask your client if that's still open.
I'm sorry, what's the name?
Costlow Wines and Liquors, 91-20 59th Avenue. It's the
91.
second closest store.
I had it listed.
I don't know if we did, but we do.
Okay, yes. Okay. 91.
20.
Yeah, I have that listed as Queens Liquors Inc.
Is that open?
Queens Liquors Inc. It's Liquors Inc. Yeah, I'm pretty sure it is. I was in the area. Queens Liquors Inc. 9120 59th Avenue. Yeah. I have it down as 3/10 of a mile.
Okay.
All right. I'm sorry to get back. And just to address that Queens Liquors Inc. I remember that because it's in a very odd location, and if you look at the map that I provided as part of the application for the closest stores, you'll see that particular store, which is 3/10 of a mile from the applicant, it's located behind Queens Boulevard in kind of an odd location. It's hard to see. It's hard to find. And it's hard to see even when you're over there in this little area behind the boulevard. Getting back, we have JF Liquors is located at 6/10 of a mile, the shortest driving distance. We reviewed that store. It has no New York State wines, no Korean, no Japanese, and only a small selection of Chinese product. 57th Avenue Liquors, no New York State product, very limited Asian products selection. Queens Liquors, 3/10 of a mile from the applicant. That's the one you were addressing earlier. It has no Asian products and no New York State products. The only store that does wine tastings in this area is Grant. None of the other stores do wine tastings. We intend on having a method of operation which entails carrying a substantial selection of Chinese, Korean, and Japanese products. We intend on having wine tastings on a regular basis. Also, a membership program with a point system that is redeemable by customers for future purposes. I had indicated to you about Rock Church. What has been stated is simply false information.
Where is
There's no way Rock Church is located within 200 feet. Again, I measured. I took the measurement.
We heard it the first time. Where does your client work? What's the liquor store name that she works at now?
I have that Legacy Wine and Liquors.
Who owns it?
This is her daughter.
Her daughter owns it.
Correct. And her daughter has nothing to do with this project. This is Miss Yee and Mr. Yee.
Is she going to continue to work there?
No, not at all. She's going to devote approximately 60 hours. She's leaving the store that she's been working in for 4 years. She's going to devote 60 hours a week to this store. She'll be the full-time manager. Mr. Yee will devote about 30 hours. He'll split his time between the restaurant and this store.
And are they, the names I have are spelled differently. What's the relationship?
They have no relationship. They're simply originally from the same town in China.
How do they know each other?
They've known each other for many, many years as family friends. The mother, Mr. Yee's mother, Miss Yee, that the families have known each other for a long, long time.
Do they live in the area?
You live where? Elmhurst. Miss Yee is in Elmhurst, which is very close to the location.
Well, the location is yeah. Then, what is she familiar with JF Liquors on 8316 Broadway?
We looked at the stores.
What are their hours?
I'm sorry?
Are they open regularly? Does she know?
Do you know whether the JF you're talking about is open regularly?
Yeah.
I don't know whether it's open regularly. I don't know whether we can make a statement confirming that or not, Mr. Chairman.
Well, ask her. Does she know?
Do you know whether JF Liquors, which is 8316 Broadway, 0.6 of a mile? Do you know that it's?
No, they don't know that.
They're not sure as to exactly what hours the store is open.
It seems like your numbers have dropped a bit. That's why.
I don't know how they're existing. I don't think that they're accurate. It's telling us they work 17 hours a day.
And I have that as the closest driving distance is 0.6 of a mile away from us.
Are you comfortable with this 300?
Yeah, I'm more comfortable with 300 than
not on the same
street one.
All right.
Are you ready to vote?
Yes.
Commissioner Ford?
I'm going to vote to approve. It's only 540 square feet. We did license someone in more than 2 years ago, over half a mile away. The numbers seem to have gone up. Closest store, their numbers seem to be going up as well. So I'm going to vote to approve.
Chairman Brown?
I'm going to vote to approve as well. It's on Queens Boulevard, and there doesn't appear to be a store on Queens Boulevard. So I think there's a public convenience and advantage to that. I don't believe it's within 200 feet of the church, and I think that there's also, at least looking at photographs, it's not clear whether that church is even on the same road, which would also be detrimental. So I don't think there is a 200-foot issue. So I'll vote to approve.
Thank you.
Next item is 1217, Salmon Eric Liquor, Inc.
This is a $5,000 civil penalty, conditional no contest plea offer. Just in mitigation of what happened, the police did come in. I believe it was around 12:20. It was a snowy night. The owner of the store was on the way going over to the store to close the store up. They were delayed. The police came in. The clerk that was there just wasn't sure what to do, was afraid to let the police in, was contacting, calling the owner. By the time that happened, the police just said, okay, you refused to let us in. And that clerk was fired.
No, but here's my problem, and the way it's written up for us, at least, and I don't know whether this is accurate or not, but when the police got there were still customers in the store. So, so they're letting customers in, but they're not letting the police in?
No, look, Mr. Chairman, I forgot. I think this may be bulletproof. I think it might be a matter of them going through the bulletproof area, getting through it. And that's what happened, I believe. And the clerk was calling the owner of the store, to see what he was supposed to do. And by the time all that was happening, I mean, obviously the police were not immediately permitted in. I mean, they've got a good record. They have no adverse history. They apologized for what happened. It was an unfortunate situation. It shouldn't have happened. And the clerk paid with his job for not permitting the police in.
Yeah, if the police are knocking on the door, there's really no excuse not to let them in. Period.
They have a legal right to be in there.
Commissioner, I'm not arguing. Unfortunately, there was a clerk that spoke little or no English. He was calling the owner, had no idea, that he should let him in, was afraid of the situation. It happened. We do have no adverse history. They've been in business a long time.
All right. 5,000 set.
Thank you.
Next item, 1305. Equa Colombo Bakery, Inc.
All right, this is an availing situation to the extent that it was the owner formed a new corporation, a new company. There was an application that was filed to transfer, but he was doing business with the new company already. So, I mean, he came to see me. I explained that, can't operate that way. He had to wait until that license had gone, the new company was approved on the transfer before he could operate with the new company. We deposited, shortly after he saw me, I deposited the license into safekeeping with the liquor authority. So he's not been, selling any beer or any products. And until such time, I told him, as it's straightened out, and the new company's application, we'd like it to be reactivated and go through the process to approval. But until that time, he can't be selling any alcoholic beverages.
All right, I'll accept 10,000.
All right, thank you very much. Have a good day.
Next item, 1261. Easy Life Restaurant and Lounge, Inc.
Leonard Fogelman, attorney for the applicant, and this is my client, who's the sole officer, director, and stockholder of the corporation. This is an application for a on-premise license on a commercial block in the Bronx. It's not a 500-foot case. He appeared before the community board. They are certainly not in opposition. It's a moderately priced, full menu.
I have to disagree with you there.
In what way, Mr.
You notified the District 13.
The district manager of Community Board 12 asked us to deny the license. This location has been a problematic site during my entire tenure as district manager. The local precinct has responded to numerous quality of life complaints. So I don't where it, and I have that written in my notes too. I don't know where you're getting the idea that they are in favor of this.
Well, my client will answer that.
Why can't you answer it?
because I asked my client whether there was problems with the community board, and he told me there were not. So that's why I'm answering the way I'm answering. Why doesn't he answer that, and then perhaps I can proceed with a little more, but why don't you answer that question, please?
Good morning. My name is Olayo Sainde. I did attend the community board. Ms. Esler, who works there, when I went back, told me everything was fine, that the precinct said it was okay to give me a chance since I wasn't a previous owner. And I did meet with Officer Cruz, who's a community officer also, who ran my record and said, they were going to give me a chance since I wasn't the previous person there.
That doesn't really explain it. We have an email from the community board asking us not to grant this license.
I attended community board myself. Like I said, I went back again to clarify things with them. Ms. Esler, who worked there, I think the board for over 20 years said, everything was fine. They did give me some requirements to get to make sure I have a security guard and an ID scanner, which I told them I'll provide, and I'll bring it back to them. That was the condition they gave me.
He's planning on having a restaurant. Obviously, there is a bar, but he's planning on having opening for lunch, closing at 12:30 a.m. during the week, closing at 2 a.m. on the weekends, serving a full food menu. He has no connection with the previous license that was there. He's been a successful businessman, and now is changing his tact, changing his lifestyle, and wants to open up a restaurant serving Nigerian food, of which there are no other Nigerian food restaurants. So he tells me in the Bronx there are a couple of African restaurants, but he's not aware of any other Nigerian restaurants. We provided a menu for you. It's only 30 tables. He will have a scanner. He will have a security guard to check IDs. He will have cameras. It's a commercial block. And
He has
obviously,
asked for music, recording, DJ, karaoke, live music, event promoters, dancing.
Yeah, this isn't. I mean, given the history of this place and the lack of experience that he has, which is 100%, he has no experience from what I can tell, and the fact that the community board has asked us not to do it, along with, it seems, the police department.
No, Mr. Chairman, I did meet with, like I said, I did speak with Officer Cruz, who came in there, made a lot of recommendations in terms of security, cameras, which I did everything. He came back and said everything was fine.
Do you understand what you've applied for on paper looks like a nightclub?
Actually, it's more of a lounge. The dancing is going to be more on the weekend because in the community in the Bronx, we do not have anything Nigerian where we meet, eat, or get some drinks. We normally have to travel to Brooklyn or Queens or New Jersey. I'm just trying to service my community, my people, so at least we have something. We don't have to drive that far.
Yeah, but you picked a location to do that in that has had significant problems in the community in the past, with the police department, with the community board, and you have no experience doing this.
I'm sorry, I wasn't aware of that, but I have a huge experience. I've been in management for over 12 years. I'm very good with management, and I have the right staff and the right team in place to make this happen.
instead of what appears to be a negative vote upcoming, can we get this adjourned and we'll request a meeting again with the community board to get the situation straightened out? Because as far as my client is concerned, he thought he had an agreement with the community board that if he was going to get a scanner and he was going to get a security guard, that they would be satisfied, and that's obviously not what they have communicated to you.
Yeah, to satisfy, I can't speak for chairman, but to satisfy me, he's also going to have to change some things on his proposed method of operation.
Yeah, I mean, I'm not going to adjourn this. This is work that should have been done before it ever came here. Mr. Fogelman, you've been doing this long enough to know that with a guy with no experience in a place like this, we're not going to give him a DJ, live music, karaoke, 3 security guards, and turn a place that was a nightclub that became a huge issue to the community into another nightclub. So I'm not giving you, there's no adjournment. I'm denying the license, but he can reapply. There's no prejudice. But I would suggest you change the method of operation.
Commissioner Ford? I'm going to deny as well on the same grounds.
Thank you.
Next item, 1274, Definus Events LLC.
After this, we can take a 2-minute break.
Get out of here.
1274.
Good morning, Michael James for the applicant. I have with me Jocelyn Reyes, the sole member of the operation, and the establishment is located at 352 Willis Avenue. It's an on-premise catering facility. The hours of operation are Saturday and Sunday, 3 to 11 p.m. There are no DJ, recorded music, and I believe 3 to 4 employees.
So why'd you? Go ahead. No, go ahead. I'll let you.
We have some information from the community board. I don't know whether you're aware of it or not, but on paper, what you gave us looks like a legitimate place. But then you go into their Facebook, and you see that they have karaoke already. They're playing beer. They're advertising beer pong and pool tables, and the police have responded on numerous occasions to the location in an effort to reduce community tensions over alleged threats made to residents due to their complaining of the adverse noise and violence concerns.
Yes, so we just spoke about, they have a tenant in the building that likes to call the police, even though there's been no violence or no actual.
Well, why don't we start with the advertising on Facebook regarding karaoke, which she didn't ask for, beer pong and pool tables, which we don't even see.
Right, so that is their prior method of operation. This is a new method of operation in compliance with the license that they would be issued, presumably be issued. So we're proposing that method of operation. That they could have done that in the past if they'd like, as you know, but now they're saying this is what their method of operation will be.
When was it licensed?
It's open now. As what? Are you open now?
Correct. It's a catering facility now.
Yeah, but it doesn't have a license.
Right, it doesn't serve alcohol at all.
So how is she advertising beer pong? In order to play beer pong, you have to have beer.
Yeah, but it wasn't an event that day.
It wasn't an event?
No, it was a picture of the table.
It was just a picture?
Yeah, it was just showing like the items that we have, but we didn't have a party that day. There was no party.
So what I'm understanding, there was no party that day, and I haven't seen the ad, and if I could see the ad, I could speak to it, but I don't think.
No, it just shows like the bouncy house, the pool table.
Right.
That we have
The outside of it just shows bouncy house. It's actually, the advertisement on the outside is purely kids, jumping on bouncy houses.
I don't care what. You're not answering my question.
Yeah, the beer pong.
On the Facebook page, it indicates that she's advertising karaoke, which she did not ask for here. She's advertising beer pong, which she's not legal to play and is not asking for here, and because she's not licensed. And we have numerous complaints, not only from the community board, but from the New York Police Department, alleging that there's been noise issues already. And they're not supposedly licensed, which would lead me to believe there's parties going on already.
No, there's cameras to show everything that goes on there.
They have a full-blown camera system. I wish the community board did invite us in for a meeting. We did notify them. I did not get any questionnaire or any indication that they had any opposition to it, and I wish I had an opportunity to respond to it. And this is the first time.
How does she explain the noise complaint?
There's a tenant in the building. Well, first, I just want to give context. I'm sorry.
No.
That she did sufficient soundproofing in the building before she went in there. There is a tenant upstairs that does complain. She doesn't have the ability to even have a DJ in that building. It's not allowed in the building whatsoever. But there's a very sensitive tenant in the building that likes to call the police. There's nothing that she can necessarily do about that other than try to just cooperate. And so, yes, the police have been called there, but not because there have been any disturbances at her place of business, but because the tenant is just very sensitive to music or very sensitive to just their business. And he should have, or that family should have understood that this is the building that they're moving into, and this business, it's commercial space on the first floor. So I don't know.
Yeah, but commercial space doesn't mean that whatever commercial entity's in there disrupts the rest of the building. That's not the way it works.
Before I signed the lease, I told the landlord I was going to use it for party.
Right. So, I mean, I fully understand what you're saying. I mean, she's taking measurements to reduce the noise. She's taking measurements to cooperate, and there's but so much she can do to actually resolve an issue that keeps persisting. I mean, I don't know.
And I get that she probably told you it's one tenant, but the community board's letter indicates to us that the complaints are coming from elected officials as well as residents, not residents
Again,
in the area.
And I understand your perspective, but I wish we had an opportunity to at least confront that before today, so that I could at least verify if that's actually true and which residents are making these complaints. I only know about one. She only knows about one.
Yeah.
So I would love to actually confront that.
Well, she must know about more because the police have shown up, it sounds like, on more than one occasion. And they've alleged that she is actually threatening people, or someone in her employ is threatening people that are complaining.
Again, I can't.
The cops have came in. They've searched the place. I let them in myself so they could look around, speak to me. We never had anything that was violent or threats were made. I have messages from the tenant upstairs, text messages that we just speak normal. Can you keep it down? Okay, not a problem. I had the party load on the base.
Right. So
that's something I've never heard
our
of.
client has a different recollection of those events. If there are any actual complaints or actual arrests, then that would be a little bit more sufficient.
Well, the Department of Environmental Protection has numerous incidents where the noise coming from that location exceeded the legal limits. They measured it.
They came once, they measured it. I had more soundproofing done, and after that, they never came again. They came once.
And they said that it was turned back up again.
I don't believe you. I'm sorry.
How was it turned back up when I had the whole ceiling was gutted and soundproofing was done twice?
When people came, the letter from the community board indicates that when you were asked by inspectors to turn the music down, you did. And then the minute they left, you turned it back up again.
But how would they know that if they left?
Because they stayed out front.
No, they didn't. That was
This
Christmas.
included loud music coming from vans parked outside the location and associated with the location.
Again, Mr. Chairman, we can't speak to if that's true or not. I understand that that's what they said.
See, everything I brought up, you can't speak to. You can't speak to the beer pong. You can't speak to the karaoke. You can't speak to the pool tables, and you can't speak to the noise complaints. So what can you speak to?
I did say that was a prior method of operation.
There is no method of operation. She can't have beer there. She's not licensed.
Have a method of operation.
It wasn't
so
used.
That's a method of business. That's how they operate their business. But what I'm saying,
They can't
she said that.
They're not licensed. They can't play beer pong.
I understand. She said that there was no beer pong on that day.
The beer
There
pong
was no
wasn't
beer
used.
pong.
We just took a picture of it to show people that they could rent it out. It wasn't that it was used at a party.
But you were willing to use it.
He's not.
Secretary, can we vote, please?
Yeah.
So we ready to vote?
Yes. Deny.
Commissioner Ford.
Deny.
I deny as well. I mean, I would go meet with the community board.
Next item, 1275. ST Corp.
Good afternoon. Isauro Fernandez for the applicant, Este Corp. I'm here with Esteban Ponce, who's the principal of the corporation. He is setting up a restaurant bar at a location known as 7905 Roosevelt Avenue. It's going to be a full restaurant and bar. His background is over 12 years of experience with French bistro, Latin bistro. He's trying to create a mix and bring that to the community that he also lives in. He lives a few blocks away from there. He's met with the community board. The community board had specific stipulations, all of which Mr. Ponce adheres to and agrees to. The hours of operation, 3 to 4 a.m. daily. However, he agrees with one of the stipulations the community board set forth, which was to stop serving alcohol 1 hour before. The security will be 2 security guards during the week, 3 during the weekends. The occupancy, even though the occupancy is 104, he does not have a PA, so he's limiting the occupancy until 74 people until he's able to get a PA.
You say that you met with the community board. it was approved March 21st, subject to specific stipulations.
Yes, sir.
Where are they?
They're attached. They're the second page of my email. It's Community Board 3Q on the top, and then they have handwritten.
I see it now, I'm sorry.
Okay, and then his affidavit is the subsequent page where we reiterate those steps, and he signed them.
Is he aware of the history of this place?
He was not aware of the specifics. He knows that the history of the location and that area is one that's had issues in the past, but he was not aware of anything specific.
Well, but somebody else with a similar history just applied today in the same area. I'm just indicating that this is an area that causes a great deal of issues for our agency with bad operations, and this place was one of those places.
Right. One of the differences that Mr. Bonse is bringing to this equation is that there was no full kitchen. He's setting up a full electric kitchen downstairs.
Did he take the DJ booth out?
Yes, there's no booth. It's just a stage. He will not have a DJ, no dancing, no cover charge. He'll have monthly events.
One form you submitted says he's going to have a DJ. The other one says he isn't. Which is it?
He's not. There's no DJ.
And then what's the 500-foot hearing questionnaire indicated there's going to be dancing while the proposed method of operation, says the 500-foot hearing questionnaire says there will not be dancing, and the method of operation in the application says there will. So which is it?
Well, no, we amended that. The proposed method of operation, there is no dancing.
Yeah, the stipulations say no dancing.
And on the proposed method of operation, there is no dancing. There will be no dancing. No cover charge, no...
I'm not going for it right away because we did it to the other people. Yeah.
Are we vote?
Yes.
Yeah, go ahead.
So I'm fine with this, but a place with a similar history, we limited the hours, and I'm going to limit the hours here at least for 6 months, till 2 a.m. across the board. Because of the past history and the area itself is problematic, and if he comes in 6 months and his history with us is clean, then we'll consider going for. No DJ, no promoters, no dancing. He can have live acoustic music and and what's he want to do? Comedy shows?
Right, different comedy shows. He has folkloric bands that come, Mexican bands, Ecuadorian bands.
So he can have comedy shows and acoustic music live, and 3 security guards. He's going to have 3 security guards every night?
No, he's having 3 security guards pursuant to the stipulation, Friday through Sunday, all day.
3 security guards. So the stipulation, that stipulation is there, yeah. But just the hours are going to change, and then no promoters and no DJs. The live music, I'm assuming, are in the stipulations.
Yes. Mr. Chairman, so then we'd be able to reapply to change that within 6 months? And
after 6 months, yes.
Yeah, and you have to come back here.
Okay.
And then obviously you have the occupancy already. Okay.
Mr. Ford?
Yes.
With that?
All good.
All good?
Yes.
Thank you.
Next item, 1279.
Wait, can we take 2 minutes?
Yes, we can take a brief recess. So get a little bit more. Phew.
In one day?
Yeah, one day.
Ask Sharif.
Sharif is sending it to you.
I know, what's it going to do with it? When is it, tomorrow?
It's tomorrow, yeah.
All right, we are back on the record after a short recess. Calling item 1279, R&D Liquor Store, Inc.
Hi, good afternoon. I'm the owner of R&D Liquor Store. I'm Harshana. My business has been growing since I started from scratch, and I need more space. I've been operating with 500 square feet roughly.
Right, so I don't see any protest to this, and you're only adding 500 square feet. It is contiguous from what I've been told from our application. So I'm going to vote to approve.
What's in the
Thank
space
you.
now? What's in the space now?
You mean the current space or the new space?
New space.
New space is nothing. It's
Thank
Thank you.
The next up I have signing is 1287. It's a Brute County case. Might be an error. Mr. Whiting?
Mr. Chairman, good afternoon. Yes, Ken Whiting on behalf of Colella Wink, a former licensee. Colella Wink, DBA Uncle Tony's, terminated their business New Year's Eve, December 31, 2018. They surrendered their license promptly. They liquidated all their business. They terminated their lease. And I found out thereafter that the insurance agent canceled the bond. The next week, we received a disciplinary action from the authority alleging that Colella Wink had a lapse in workers' compensation coverage back in 2018. Indeed, that is true. There was a misplaced premium notice. There was a lapse. It was reinstated. It was all explained to the Workers' Compensation Board over a year ago. We resolved it with a civil penalty. And my initial suggestion is that in view of the fact that they are former licensee, that the authority not exercise jurisdiction. I've been told by legal authority up in your office in Albany that there is a section that allows the authority to exercise jurisdiction for 30 days. I guess that's section 127. But I think it's discretionary. So my first request is, why bother?
All of our enforcement is discretionary.
Well, I'm asking in particular to exercise in this situation. This is a former licensee.
All right. Letter of warning.
Thank you.
Yeah, letter of warning. Let me kick this shit out.
I forgot somebody has to get out of here.
Next item, 1262, Little Wisco LLC. I believe we have a few people signed in for this.
Yes, we do.
Anybody here for Little Wisco LLC, DBA?
Yes.
Come on.
Yes. Palillo there?
Hello.
Hold on. Is Mr. Palillo there?
Yes, I was just going to say I think he stepped out for a phone call. Here he is.
Oh, okay. I just didn't want to start if he's not there.
Thank you. I would like to also have him here.
Good afternoon. How are you?
Good.
My name is Frank Palillo.
We know. Okay. Is there opposition there?
Yes, sir.
Okay.
You have anything to say?
Everybody who's in opposition to this, please come up.
Hi. Do I speak here?
Yes.
Hi. My name is Mark Levy. I'm a resident of the block where Gabe Stuhlman wants to apply an extension of license to install his restaurant in the backyard. This block, located between West 4th, 7th Avenue, Charles Street, and West End, is a highly residential block where live about 80 families. The center of the block, where all the gardens are touching each other, is a high echo chamber where all families' life are connected. Gabe Stuhlman already owns 4 or 5 restaurants, and extending more tables in the backyard of his restaurant does not change anything to the survivability of his business, except that he might make more money by destroying the life of all of his neighbors. Already, the entrance of our street is surrounded by Gabe's 2 restaurants facing each other, where during all summer, spring, and fall, the windows are open.
Sir, I don't want to hear about the other 2 restaurants. We're talking about this one.
Well, okay. Well, this one restaurant, Federa, already Gabe Stuhlman used the sub-basement of his restaurants to serve alcohol in an unlicensed room where, of course, the customer were in danger in case of fire because there is absolutely no fire escape going out of that. Gabe Stuhlman already had a denial of his extension license at the CB2 hearing. And if I was talking about the 2 other restaurants, it's because the 3 restaurants are in a few feet of each of them, and are already have dramatically changed the quality of life of all the neighbors of this street. Now, by applying, by also misleading the DOB in the nature of the work he wants to do in the garden, by misleading the DOB and applying an
alteration to an alteration 1.
An alteration 2 instead an alteration 1 permit. What Gabe Stuhlman wants to do is to serve like liquor to his customer and organize party in the garden. Sir, I have 2 children, 9 years old, 3 years old. I've been living in this street for 11 years. My children, during the nice day, cannot get home into their home without crossing Gabe Stuhlman patrons drinking alcohol all around. I don't think it would be fair that they also have to suffer this kind of disturbance in their garden, and that the life of about 80 families should be strongly affected because Mr. Stuhlman wants to make more money by selling alcohol literally in our gardens and in our community. Thank you very much.
Thank you.
I am also opposed. I'm the next door neighbor of Gabe Stuhlman. Thank you. My name is Gilda Laval. Gilda Laval, and I live at 241, which is right next door to 239 West 4th Street. Thank you for granting a full board hearing regarding Little Wisco's alteration application to extend their liquor license to Fedora's Restaurant in 239 West 4th Street. For 70 years, I've lived at 241 West 4th Street, next door to Fedora. It's been my family's home since 1917. My father, Dr. Laval, a surgeon and professor at Cornell New York Hospital, provided medical care to neighbors and their families in his office in our building until he passed away in 1981. I am the owner, property manager, and longtime resident of 241 West 4th Street. I and my tenants have very grave concerns about this alteration application. On March 21st, 2019, the board members of Community Board 2 voted unanimously recommending denial of this alteration application. As stated in CB2's full board minutes of that date, Gabe Stuhlman, principal owner of Fedora Restaurant at that time, and I quote, never presented approved work permits or drawings from New York City Department of Buildings or from the Landmarks Preservation Commission for the proposed rear yard addition. Since then, my architect located a certificate of no effect from the Landmarks Preservation Commission for interior renovations in the basement only. The DOB plans signed and stamped April 9th, 2019 by Mr. Stuhlman's architect are also for minor interior renovation of existing restaurant space. No drawings of a rear extension. The DOB alteration Type 2 Directive 14 application filed on May 3rd, 2019, and the description of the work is, and I quote, renovate existing restaurant tenant space, remove non-load-bearing partitions and finishes, install 2 sprinkler heads off domestic line, no change of use, egress, or occupancy, close quotes. The post-approval amendment to Alteration Type 2, or PAA, was filed with the DOB April 4th, 2019, and approved on June 5th, 2019. And I quote, rear addition as shown on plans. Unfortunately, to date, my architect has been unable to review the actual plans that were submitted, only the text in the application. DOB did not make those plans available for view. According to my architect, this alteration, Type 2, Directive 14, is for interior renovations. Constructing an exterior extension requires filing an alteration Type 1 with the DOB. My architect discovered serious errors in the approval and filing of the PAA, or post-approval application, as an alteration Type 2, Directive 14. Alteration Type 2s are filed for work that do not alter the shape of the building or occupancy. However, in this case, the shape of the building will change with a new rear extension. Additions to structures are filed as alteration.
Ma'am,
yes.
We get your point, but the argument you're making here is really should be directed at DOB, not us.
My architect wrote to them.
Well, I get that, but we don't determine whether an addition gets built or not.
The thing
that
is,
has nothing to do
I
with us.
understand. I'm trying to say that he's asking for a license for a non-existing place that has been filed incorrectly, has not fulfilled any of the requirements.
My point is, if he gets that license today, he's going to have to show to us that it was filed correctly before he's ever allowed to serve alcohol in there. He's going to have every approval from the city of New York, whether there's alcohol there or not. So what you're arguing to us, we have no control over. So you're wasting our.
I'm under. Okay, I want to also say that it would be. I feel it would be premature giving someone who has already served liquor in derogation of his liquor license another privilege to serve in a non-existent extension that hasn't been filed properly. It's a mess. This is premature. And the engineer said it was dangerous to my property. And I'm sorry if that isn't relevant, but thank you for your time.
It is relevant. It's just that we have no power to do anything about that.
Oh, it's okay.
Well, but you're going to grant a license to someone who has not done it. Okay. Thank you for your time.
He cannot use anything until that he gets all. Assuming that this is granted, he cannot go and use that addition until all of those approvals that you're talking about and all those filings that you're talking about are approved by DOB. That goes without saying. So I understand your concern, but we don't have any power. We don't have any power over DOB.
But you can give a license to a non-existent space. Is that it?
We can approve it. He can't use it until the space exists and is approved. That's all we can do.
Thank you for your time.
Good afternoon. Thank you for allowing us to have this full board hearing. I live 2 doors down from Fedora. I'm very concerned, obviously, for the health and well-being.
Put your name on the record, please.
Marilyn Bai. I live 2 doors down from Fedora. I'm very concerned for the health and well-being of my neighbor, Ms. Lavelle, who just spoke. This has all been very upside down. It happened at the CB2 Community Board meeting in March, where he had a unanimous denial from the board members, because I know you have nothing to do with DOB, but he's kept the what he wants to build down there secret from his neighbors, secret from CB2. This is the Greenwich Village Historic, district, and he's trying to evade the Landmark Preservation Commission. And all types of ways. Even if you just want to change a window in our neighborhood, you have to go through a lot of things. But anyway, besides from that, for 8 years, he had an unlicensed room in the sub-basement of Fedora. This room was underground with no windows, no secondary egress. This is an operator who doesn't mind putting people in harm's way. And now with this extension, if it's not done properly, and, we're going to have to fight the DOB too, that he's going to put in harm's way the foundation of actually Miss Lavelle's building, and also kill off all the plants and greenery that we need to purify the air. And the interior of this block is a mess. It's loaded with HVAC units, and the greenery that we have back there is some respite from the street, which is filled with, we have 3 of Mr. Stuhlman's, bars right there on the street. And it would be really a terrible precedent for the SLA to grant a license for anything to an operator who's already terribly mishandled his, license. I'm sorry. Okay, that's all I have to say, and I greatly thank you. I'm sorry, but this has been a very emotional and trying situation for a lot of neighbors on the block. We're very concerned about our quality of life, which has greatly gone downhill because it used to be a very family-friendly street, and greatly appreciate your consideration. But this is a mess, and I hope you deny this outright, because I think you have a civic responsibility to do so. Thank you very much.
Thank you.
Good afternoon, Carter Booth, here on behalf of Community Board 2. Our position on this was a unanimous recommendation to deny the alteration. There was one recusal. One of our board members is an investor in this premise. recommendation was unanimous because a full presentation was not made to Community Board 2 at the time of this application, and we had asked the licensee if they'd like to come back to present this the following month, and they declined. And so that's where we stand today. So I'm not exactly sure all the different materials that you have in front of you that you're reviewing, but there were a number of unanswered questions that weren't resolved to the satisfaction of the Community Board. As you've heard from a number of the neighbors, the application includes significant changes that will have significant impacts. And without fully understanding what those changes are, it's hard to understand how this can move forward. As you guys are aware, this is an iconic neighborhood. This is a great place to have a restaurant. The licensee already exists here. And there's a couple of nuances in the way that this has been described that I think characterizes some of the differences of why you hear the local neighbors having so many issues. This is not enclosing the rear yard. This is building an addition onto the building, which requires excavation in the rear yard, putting in new footings, etc. The location is also not located on the ground floor. It's actually a basement level. And as a result, you have different type of work. And it's not just like you're putting up a glass structure around a rear yard. The paperwork I think that you have in front of you identifies this as the ground floor and basement, but the premises is actually the basement and subcellar. From what I've seen, and I hadn't planned on being here today, so I didn't fully review all the materials. Somebody else was supposed to be here. But from what I've seen, much of the correspondence that you received with respect to this application actually isn't relevant to this application. It was there's a petition that was presented that had to do with the rear yard, which was outdoor seating, not an enclosure. There are quite a few letters with respect to Mr. Stolman that are...
I don't know if that's accurate. The stuff that I'm looking at, and I don't know what these plans are, but they clearly show that are signed by, and they put their addresses there, they're signed by residents.
I understand.
That shows that it's an enclosed structure.
Right, but there's also a petition that you have there that I think is 4 pages that's not relevant to this application. You have letters from 2017 from a number of different other other businesses testifying to Gabe's character that aren't relevant to this application, including a letter from our local state senator, which is not in response to this application. I
mean, wouldn't you say, and you're correct about the petition, but wouldn't you say that the backyard cafe is more intrusive than an addition, at least on a permanent basis?
But that's not what we're discussing. As you said before, we're discussing the application that's here before us. And that's why we had asked the applicant to come back to further discuss this. And they chose not to do so. So that's where we are now.
So let me ask you this.
Sure.
Because I think this gets to the heart of it, and I'm assuming that they've done this before they got approved for building because they want to make sure that they can serve alcohol in it if they are allowed to build it. But assuming that they are allowed to build it, which I have no say over whatsoever, and none of us do here. You do, I don't. Is there any doubt in your mind that if this was built and enclosed that they would be licensed, since they're already licensed and it's contiguous?
Well, I think that the question here is that there's going to be an impact, and those are the issues that we haven't discussed.
The impact, and I'm not questioning whether there's going to be an impact. What I'm saying is, and it sounds like the impact is going to be the construction, and the impact is going to be the extension of the premises into these backyards. I'm not minimizing that at all. That's just not our purview. And
there's going to
whether
be
that happens or not is up to the city of New York and you and the client.
Well, one of the impacts of the alteration are going to be a larger number of clientele. This is going to have a much larger seating capacity. That's number one. Number two, there's going to be operable windows that are in the rear extension.
Well,
That's
we
another
can-
impact.
We can make sure those are shown.
Right, and as far as the one of the other issues is that there's also disagreement. And while I understand this is not your purview, it's the Department of Buildings' purview, there is disagreement on what documentation will need to be shown to the liquor authority as far as obtaining this. As we've discussed before outside of this setting, this is where the issues come, which is why I've requested that the Department of Buildings specifically have a liaison with the liquor authority. In this particular case, the letter of no objection that you have on file for this premise that you've accepted specifically states, if this building is hereafter altered or its use changes, an application for such an alteration work or change of use must be filed, and a certificate of occupancy shall be issued pursuant to Article 22 of Subchapter 1 of the Administrative Code of New York City. As far as in this particular case, the applicant is telling you that they do not need to file for a new certificate of occupancy when the paperwork that you have clearly says that. So what we're talking about here
Where are they saying they don't have to apply for a new certificate of occupancy?
they're saying that by filing for an Alt 2 application, which does not include
But
obtaining a new certificate of occupancy.
I can tell you that we wouldn't allow use of that room, and somebody correct me if I'm wrong at this table. We wouldn't allow use of that room without a certificate of occupancy.
Right, and the argument that they're making is that there are no changes, so that they don't need to obtain a new certificate of occupancy. This is specifically the unanswered questions, which is why our board voted unanimously to recommend denial. And I remind you,
It's not an unanswered question to me. They're building an addition onto their space, and that addition is going to add square footage. It's going to require a certificate of occupancy.
Mr. Booth, they're either going to need a certificate of occupancy or something the Department of Buildings saying they don't need a certificate of occupancy. They'll need something from.
Well, I understand. Well, but these are the questions we generally ask people to explain the pathway that they're going to take. It's not unreasonable for us to ask these questions, and it's a part of the review process that we do. As you are aware, we're the only part of this process that looks at this holistically. Every other stage of this, an agency looks at it in its scope. We're looking at this holistically. And it's not unreasonable to ask, how is this going to be obtained? How is this going to be done? We're not questioning what the paperwork that they're issuing in the end. We're asking what are the steps that they're going to do to go get that. Filing an application isn't a fishing expedition to see what you're going to get approved or not. It's understanding what's going to happen, laying it out. So that's why we have the issues. And I have to say, in this particular case, it's also unusual that you have a unanimous recommendation from our board in this particular case that outlines, as the resolution does, all the issues, including the fact that one of our board members is an investor in this premises. Thanks.
One of the board members is an investor?
That's correct.
And he voted or not?
No, they're recused. That's why there's one recusal.
Oh, okay. Did they leave?
Good morning, afternoon. This premises has been a restaurant since 1917. It's been Fedora since 1952. We are proposing to add 6 tables and 18 seats to a premises that's been there licensed for 9 years and never had an issue with the State Liquor Authority. The reason, in actuality, let me back up. We, in January, filed an application with the community board to license the backyard. We wanted to leave it unenclosed so that it could be used for dining only with no music. The community board disapproved it. One of the co-chairs of the committee said, if you could enclose this, I would have a different opinion.
That's only one person.
Correct. We then, the following month, went back to the community board with our plans to enclose the backyard. It's true the community board asked us to come back, but they asked us to come back with approved building department plans. As you are probably aware, last week, I forwarded to you the approved building department plans that were just approved June 5th. I'm sorry. I don't know what date. They were sometime in June. we could not realistically wait 4 months to go back to the community board. The bottom line is the plans are approved, and Gabe would like to address some of these issues.
Talk about the development. Hello, commissioners and chairpersons. My name is Gabriel Stolman. I am the licensee. I am a West Village operator and businessman. I am also a West Village resident. I am also a West Village parent of 2 children that go to PS3. I am engaged and invested in this community in every possible way. I can't speak on to the motives of why people might try to portray me as a bad operator, but I know the kind of person I am. We fundraise annually for the Christopher Street Park. We fundraise annually for the public schools and the nursery schools in our neighborhood. We fundraise annually for the LGBT community in all of the programs in our neighborhood. I believe our restaurants make our community safer, friendlier, and we brighten our streets. I think it's worth noting, of the opposition, 2 of the individuals, Mark and Marilyn, their windows and their apartments do not directly connect to the immediate vicinity of this garden. And therefore, they are not that much impacted or affected by the conversation of this extension. As Frank said, Fedora's been in continuous business since 1952. We currently have 40 seats, and that is inclusive of the bar. We serve dinner only 7 nights a week. We are seeking permission to extend our pace, as you see in the extension of the backyard, to have an extra 18 seats. These extra 18 seats will allow us to make some more revenue, which is, I believe, an okay goal. It will also allow us the opportunity to have a private dining room where we can have group dinners for up to 18 people, something that we have no ability to have a private space within the current room. As Frank also mentioned, when I originally applied, I wanted to have an open-air garden. We applied to the Department of Buildings for permission for use as a dining open-air place, and we were given permission from Department of Buildings. I went to CB2 with it, and exactly as Frank suggested, there was a lot of concern about the amount of noise that we would create and the suggestions of echo chamber, and it was, you know what, this is a big problem if it's open air. Consider enclosing it. I've done that, and by enclosing it, it will take me significantly more time, cost me significantly more money, and I also believe it makes it less special. But I'm still willing to do all of that, which I think is beyond an effort to compromise and listen to the concerns of my neighbors, of which I am also a neighbor there too. So I'm here willing to spend more money, take more time, put more effort, and enclose it so that we don't have these concerns of the noise in the echo chamber and it be a fully enclosed place. Lastly, and the last thing that I think is really important to mention, there has been stated here that there is, for some reason, not a substantial amount of community support. In some of those petitions that you have in front of you, when you look at the exact, 3 buildings where Fedora is right in the middle, and then the buildings directly to the left and directly to the right. If you look at the commercial and residential, there's approximately 9 businesses or apartments that are the most directly impacted. Of those 9, 1 person is here in opposition, and 6 have signed letters of support of exactly what I want to do. And these are people that live directly above, directly to the side, and are closer in proximity than some of the opposition. I think that the community support is overwhelmingly behind and in majority of this. And I ask for you to please allow us permission to build this extension according to the codes and everything that DOB and LPC approves. And if we get it all built and signed off right, I ask permission to extend my use into those extra 18 seats, please.
What would the hours?
The hours of operation of that extension specifically, is that the question?
Yes.
It would be the exact same as the rest of the restaurant. It would close at the same time as the front half. Our current hours of operation right now, we operate Sunday and Monday from 6 p.m. to 10 p.m. We operate Tuesday and Wednesday from 6 p.m. to 11 p.m. We operate on Thursday from 6 p.m. to midnight, and we operate on Friday and Saturday from 6 p.m. till 1:30. Although we do have a 2 a.m. license 7 days a week, we don't use it.
Has DOB approved all these plans?
Yes.
And
I'm sorry. People are shouting behind me. I apologize for that. They're speaking out of turn. Yes, the Department of Buildings has approved all these plans. I have my architect here. We also forwarded you the approved plans for the enclosed extension. I'm happy to have my architect address any of the questions raised.
Is this subject to historical review as well?
May I now have my architect address any of those questions, please?
Yeah.
Good afternoon. My name's Alta Indelman. I'm the architect for this project. I have approved plans from the DOB. We are in progress on approvals at LPC, but as a rear yard extension, there's a lot of liberty with LPC. We're working at staff level, and in order to go to LPC for their approval, particularly on something that is as of right approved at the DOB, they require that the zoning be pre-approved by DOB or LPC will not approve. And so we've gone through the proper sequence by getting our zoning approved at DOB. We've gone through the proper process at DOB. I'm a seasoned architect. I do this type of work all the time. I've done many additions in the city that do not require certificate occupancy changes or certificates of occupancy. This is one of them. It's continued use. There's no change of use. It is the basement level, which is the ground floor of the building. It's confusing to some people as to what's considered first floor or basement. People used to historically call it the garden level. This is the garden level.
How long does a project like this take to get approved and then constructed?
The project's been approved at the DOB. We're in progress at LPC. I would imagine that I have no knowledge of exactly how long LPC staff will take to
you just told me that you do many of these. Approximately how long does it take to get it approved and then built?
The approval at DOB has taken place. The approval at LPC, I'm assuming 8 weeks at the moment. That's my schedule projected currently. Construction within 6 months. Completion probably sooner, but I'm trying to, it's the real world, and sometimes things take a little bit longer. It's a slab on grade procedure. We are not doing a sub-basement. We're not creating any additional basement space. All the proper precautions of structural, properly recorded, inspected, and so forth will take place, as is always the case. There's nothing unusual.
Is this being built on top of an existing platform?
It is not.
No, they're going to put footings down and everything, right?
It's a slab on grade type of construction in order to reasonably align with the existing floor level of the restaurant so that we don't create any additional steps or impediments, because one is not allowed to increase any handicapped, we have a little ramp inside. It's all a simple, you just walk right through. In order to continue that floor level close enough to make it technically feasible, we have to dig down a little bit to get our footings below the frost line and to establish a slab on grade approximately at the level or close to it of the existing restaurant floor. We are not creating a crawl space. We're not creating a basement. We are not excavating any further down than to meet the existing footings.
Okay. All right.
Standard slab on grade. It's the easiest, least invasive, requires the least amount of structural reinforcement. We, too, are conscious, obviously, as an architect and owner of the facility, we're conscious of trying to, make this as easy, quick, and painless for us and consequently for the neighbors. There's no value to us in making this a complicated construction project.
Is it to be an actual closed roof or some type of canopy or awning or something like that?
It's a fully enclosed. It is fully enclosed. Now there's a partial canopy at the rear currently that is not. It's a somewhat slapdash situation that's been there probably for 80 years. That will be removed, and we're leaving the existing rear wall of the existing addition that's part of the existing building intact. We are not changing that. We're not removing it. So there's very little intervention on the structure, on the existing structure. That's something that the Landmarks Commission likes. They like to retain rear walls. It's also structurally the safest, least invasive way to proceed with this installation. We're using the opening at the existing door to continue the flow of persons into this room. We're creating a single room.
We're going to take 2 minutes with the talk to council.
All right, we are back on the record on item 1262. We're at the conference with council.
May I continue to clarify what I was...
Hold on.
Okay, sure thing. Yeah, no problem.
What do you want to clarify?
I wanted to clarify for the record that the Department of Buildings has determined that no C of O or C of O modification is required for this application. This is standard procedure for an application of this nature that has no change to occupancy or use. It's in a commercial zone. It's zoned properly. It has
Whatever they say, they're going to have to give us something in writing that attests to that. That's the only thing I'm saying.
In general, the approved plans are that attestation
Well,
because...
not in this agency. We need a letter signed by somebody that says there's no, whatever the letter says. Our lawyer will be the one to determine that, but we're not going to take plans that say, okay, here's the plans and we don't need to see above. We need a letter from them saying this is legal. But that's beside the point. Does anyone else have anything else to say? No, Mr. Booth, sit down. You don't have to. You don't need anything. Go ahead. Anyone else?
My question for you in
Is
terms
there anybody
of-
else?
Anybody else? Okay.
Anybody else?
Yeah.
Who hasn't spoken?
Hasn't spoken.
I would like to I can't say anything. I'd just like
Is
to
there
say
anybody
that.
else, Matt, is there anybody else
Yes.
who has
I'd
not
love to
spoken?
speak. I haven't spoken
Is there
yet. I'm
support
sorry.
or
Thank you.
opposition?
He has not spoken. Go ahead.
I'm here in support. My name's Brian Bartles. I'm an employee of Happy Cooking, a managing partner, but also a resident of the West Village. I live on McDougal Street. I have been working with Happy Cooking for 10 years now, and I'm very proud to be a part of it. We are a great neighborhood restaurant community family, and we go so far as to even put dog bowls out on the sidewalk for our neighbors. It's as simple as that. We're just thoughtful, and we'll do everything we can to make it a better neighborhood for people, and I love being a part of it. Thank you very much.
Thank you.
Hi there. My name is Erin Pallison. I'm a current director in the company and also a former general manager of Fedora specifically. And just like Brian just said, this is a company that 3 years ago, before I worked here, specifically sought out because of the reputation of what Gabriel and the team does to make neighborhood restaurants, to keep the community in mind, to create places where people literally come to Fedora 5 nights a week for dinner as their second home. That's the type of place we try to create, and I think we do every single day.
Okay, thank you.
Hi, my name is Ted Friedman. I'm the current general manager of Fedora. I've been with Happy Cooking for 2.5 years, which is also the entire time that I've lived in New York. And it was very important to me to find an employer that had a sense of community and that could also provide me with a work home. And I've been very fortunate to work with Gabriel and many of the people that are speaking on our behalf today for the duration of my time in New York. And I'd also just like to mention that as a manager for the company, I've made many friends in the West Village community, some of whom are my closest in the city. And that's all I have to say. Thank you.
Thank you.
There are other people here, but they'll be saying the same thing, so we're not going to waste your time.
How many?
Just one more.
Okay. So the one question I have for you is, why is this filed now?
Why is this filed now?
Yeah.
Because the building department plans are approved, because LPC is about 6 to 8 weeks away, and we want to start construction in September.
But it appears to me that, and I get that they were approved, but it's obvious that the community board has not had an opportunity to look at the plans. And I don't think, and I think you probably know this as well, I don't think that if they're allowed to build this, that there's going to be any question that it's going to get licensed in some capacity. And the community board has not even had a chance to weigh in on windows or anything. And I do generally, particularly in this neighborhood, want to hear that. And the biggest issue here is this thing going to get built, in my mind? It's not whether it's going to be able to serve alcohol or not. Because if it gets built, they're going to be able to serve it. It's connected to the restaurant. And it's only 18 people. So I'm wondering, in my mind, your architect said 8 months out. And I'm not saying she's inaccurate, but I would add probably 2 more to that, because it's obvious that there's going to be opposition to this.
There's two answers to there's 2 parts to your question. The first is that we're clearly not going to build this thing if we're not going to be able to use it.
Well, I'm basically telling you are going to be able to use it, but I'm questioning whether you're going to be able to build it.
The second part is, by virtue of the approved building department plans, the building department has given their permission for us to build it.
They have, but the land preservation has not.
That's my next step.
I know that, but that's also frequently the hardest step.
I also just want to, as a clarification, the commissioner of the Department of Buildings in Manhattan has also advised us that challenges to these can't be made until a permit is issued. And so if the neighbors challenge this, they can't. Right, that's just speaking to that point.
So basically, you're asking for a license that may be, I'm not saying this because I don't build anything in New York City, but I'm assuming 8 months is her best scenario, and it could be worse than that. And I don't know why we would be licensing something that could be unlicensed for 12 or 14 months.
You'd only be approving it until such time as I complied with the conditions of approval.
I know that, but I don't know that the wait is going to hurt anybody, and it's certainly going to help the community board, and it's going to help me get a better handle on the effects that this is going to have to the people that live in that backyard.
This must I know for a fact.
Well, he knows that.
Yeah, I mean, I guess my huge fear or concern, and the reason why I'm going about this process is, I don't want to build this and then be denied at the community board level or at the state level, and I drop all the money to build this and then I can't use it.
I can tell. I mean, I'm not concerned.
That's why
I'm not concerned that you're not going to be able that you wouldn't be able to use it. I just would rather that all of these approvals go through and that the construction is started. I mean, the community board is irrational at times, but they're not this irrational.
I mean, I don't know.
Well, it's open, but so then,
I just think this is premature.
What are you proposing, Mr. Chairman?
I think I'm going to vote to deny it based on the fact that I'm not really comfortable that this is not all covered yet.
Okay, well, may I suggest that we table it for 90 days?
Can the architect address the LPC part?
Or the architect wants to address the LPC issue? Go ahead.
No, she can't do it here today. It's not going to make me feel
Can't do
better.
it today. Let's table it for 90 days.
Mr. Booth, does 90 days give you a chance to look at these plans, your people?
Sure. I mean, it can. I mean,
I don't know.
I don't know if that's enough time for this.
Where are you?
I'm inclined to approve, contingent upon all the other approvals being obtained.
All right, I'm going to deny it. And I think your best bet is to ask for a recon, and more than likely you'll have 3 commissioners here then, and hopefully be further along in the process.
So we have a vote to approve.
I have a vote to approve, contingent upon all the other approvals and licenses, everything else obtained, and
it's not the end of the world.
And then I would recommend that you get whatever you can to the community board that's been approved by the building department between now and the reconsideration. And then when we do the reconsideration, Commissioner Fan will be here. I'll make sure of that.
Thank you.
Thank you.
so I don't think we used to it.
No.
I don't think I remember all.
Next item,
So that'll be
1283, Dre's Wine and Roses Lounge.
1283?
You only have 3 of them. Thank you.
Good afternoon. My name is Andre Noble.
Thanks, guys.
As you know, as long as I've been here, this is the first one of these I've ever seen. A request to rescind full board approval of an application. Who was Jen Reed Wilson, who was arrested? I look at the police report for date November 30th last year. Arresting officer information obtained instead name of subject police after Jen Reed Wilson.
You know why you're here?
Not really, Your Honor.
The promoter of the party was unable to provide a valid liquor license when the officers asked. The owner of the premises also where the party not allowed the party to continue.
All right, so he doesn't know why he's here. So let me tell you why you're here. On December 5th, we conditionally approved your license.
Correct.
at the board level. Here, we all did it.
Yes.
That approval is conditional on you fulfilling certain requirements before you're allowed to operate. On December 10th, we gave you the conditional approval letter, and at this point, those conditions are still not fulfilled. But that's beside the point, because on November 30th of last year, an officer in the New York City Police Department conducted a business inspection at your premise. This is before you were even conditionally approved, and found that there was a promoter at the venue without a liquor license and liquor was being served. And additionally, you, as the owner of the premise, was aware of the occurring party and allowed it to continue. And the premise was also found to be selling edible marijuana, which was recovered and vouchered by the precinct. You don't know any of this went on?
That's not true, Your Honor. What it was...
Was it on November 30th?
Yes.
And was alcohol being served? By anybody? By anybody at the premise?
I'm not sure, Your Honor. I wasn't there, to be honest with you.
It says you were there.
No, I wasn't there, Your Honor.
So, but there was a party there.
It wasn't a party. It was a pop-up shop that was selling clothes. Was none supposed to be to do with alcohol. And
well, how does the police know that you were aware that the party was allowed to happen and then you allowed it to continue? Did they talk to you?
No, Your Honor. What they did, after I got the conditional approved with you guys, they called me in for a meeting saying that they got information that I had an approval by the SLA, at which time on December 19th, they issued me a summons for what happened on November 30th.
And what was the summons for?
The summons was
Unlicensed bottle club. I'll help you out.
Yes.
So that would indicate to me that they found that alcohol was being served by someone at your premises on November 30th.
Prior to you being conditionally approved by us to do that.
Yes.
That's... Counsel, if there's anything else that we have on this establishment?
Yeah, it looks like our investigators spoke with the police, and there was another arrest there on December 14th, 2015.
For what?
Unlicensed power.
And part of the issue is also the fact that when you were approved with no DJs, live music, or promoters. And
correct.
the guy having the party was a promoter.
There was no party there.
Well, I don't care what you call it, but they're serving alcohol, they're selling edible marijuana. That to me is a party. So your approval on my end is rescinded.
Are you rescinding and then disapproving the application?
Yes, and disapproving.
Same
For
here.
cause.
Same here. Thank you. What else we got?
Next item is 1315, La View Catering, Inc.
Is that you?
Mr. McCallum.
Yeah. All right. You're looking confused back there.
Good afternoon. The client signed in earlier, threw me off. Good afternoon, everyone. I'm here with Yuri, one of the partners here. It's a conditional no contest plea, civil penalty. They have a security guard company now they maintain, and they're working with other counsel to file for the reporting the change in method of operation to add the security guard.
4007.
Thank you very much. I'll be back.
Next items 1215, 1216, Elen Adorn, Inc.
Hello, Council. Good afternoon. Thank you for seeing me. My name is Marva Babel. I'm the owner and operator for Alima Door and DBA Ode to Babel in Brooklyn. I'm here to plead not guilty to some of the summonses that were issued.
You already entered no contest plea.
I did not realize that I meant to say no contest because I don't want it to be. I wasn't sure if that meant it was not guilty or something that is no contest for me to present my case.
Well, what do you want to do? If you wanted to present a case, you were going to have to do it in front of an ALJ and go to hearing. If you want to plead no contest, which means you're essentially saying that all of the violations are accurate, and we fine you, then you can do that here. So which do you want to do?
Well, I'd rather plead not guilty because, yeah.
All right, back to counsel's office. You'll get a letter.
Is it I'm sorry, pardon.
I'm sending it because you want to plead not guilty. We're sending it back to our counsel's office. They will send you a letter about what the next steps are. You'll go to hearing and you can put on witnesses, and they'll have to put on witnesses.
Okay, well, is this for both summonses? Because I had two. I just want to make sure both are
everything.
Yes, both summonses.
Yes.
Okay. Okay. Thank you very much.
Next, we got 1241 and 1246, Lens Bar and Grill, Ltd.
So, good afternoon, Matthew Leone for the licensee. This is a conditional no contest plea for a cancellation and bond claim.
Well, accept.
Thank you.
Next item, 1285, Natalia Barcorp. 1285.
Yeah, this is a conditional no contest plea as well to settle the charges for a $3,000 civil penalty.
Accept.
Okay, thank you.
Next item, 1286, EDJD Properties, Inc.
So, is there anybody here?
Yeah. Yes, I'm here. Good afternoon. My name is Benjamin Korngut, here for EDJD. This is a not guilty plea. There were 4 charges filed initially. One was sustained by the ALJ, and that charge was failure to conform with the method of operation. The licensee acknowledges that they hired a manager. They don't dispute that. At the time they opened...
All right, so sustain 1, dismiss 2, 3, and 4, 1,500.
1,500 is exactly what I was going to say.
Thank you.
Next item, 1297, Patsy's Bay Ridge, LLC.
I told you I'd be back. Thomas McCowan on behalf of Patsy's Bay Ridge, conditional no contest plea. I kind of laid out what the violations were, and they have been rectified, and respectfully request you accept.
6,000, so.
Oh, so what was the gambling?
It was March Madness boxes.
All right.
And I told them you can't do it.
Next items, 1276 and 1277, Bar 13 Inc.
Conditional no contest plea. There were a number of charges, all technical in nature. No underage, no violence. I worked through with counsel's office. Some charges were dropped. At the end, this is what we came up with, a CNC. And another...
Are you working with them here? Because they're heading in a bad direction.
Yeah. I've admonished them. I've gone over it. I have a new address because they, on notices of pleading, they don't get... This is the one, if you recall, they're above a hardware store and they don't get their mailings. But in the end, I told them, guys, the ice is melting around you, and we'll see what happens.
Yes, it is. I'll accept.
Yeah.
Thank you.
It's all silly, stupid stuff, too,
It is. It is. A curtain over a doorway. Dumb.
Dumb stuff.
Yep.
Next item, 1224, Maradona Inc.
This is a conditional no contest plea. I'm pinch hitting for Terrence Flynn. His son's graduating high school this afternoon, so it's a CNC for cancellation and bond claim.
Did he invite you to the party?
Well, that would be every day with Mr. Flynn.
No, the graduation party.
No, I did not. No.
Oh,
All right. Have a good weekend. Thank you, Jen. Thank you.
Next item, 1244 and 1245, El Chivito de Carmen Restaurant, Inc.
Who's that?
Someone signed in. There we go.
Yeah. Good afternoon, sir. Oh, my lawyer's not here, but I don't know what to do though.
Who's your lawyer?
Tim Howard.
Who? Howard?
Was he supposed to come?
Yeah, calling. He said he'd be here like 20 minutes, but I'm still waiting though.
You know, this is also just dumb stuff. Rear exit light, maximum occupancy sign, can't talk today, books and records, emergency lighting, visibility, flame-proof curtains, security guard roster, just silly stuff that should not be an issue.
Right.
You offered 4, I was going to counter at 5.
We should wait for We'll wait. We have other cases.
Have a seat, and hopefully the lawyer will get here in the next 20 minutes.
We still have other cases. We'll do those and wait for your attorney for a few minutes. Okay?
Sure. Thank you, sir.
Next item, 1253, Erzuli Corporation.
Good afternoon, Dawood Nelson, counsel for Erzuli Corp. This is a CNC plea offer for civil penalties for fire code violations that we all have corrected and requested to accept the plea.
What are they doing about the noise?
So they no longer. So they're right now they're in wait because their license actually expired. So we're looking for reconsideration for renewal. So as of right now, this is the time that they actually have tried to regroup and assess what type of noise issues and concerns that the community would have that they will no longer be doing, and making sure that the crowd, any noise will be kept to a minimum going forward.
All right. Accept.
Thank you.
I have nothing else signed in.
No one else signed.
Okay, we're going to proceed with the other items until the attorney shows up. All right. 1218.
Sustain 1, 2, and 3. Dismiss 4. Sustain 5. Dismiss 6. Sustain 7 and 8.
You know, there's still no explanation of this
Jimmy,
charge.
we got something from...
Yeah, we did. They were all no contested before the hearing. That's why the ALJ never wrote about it. I'll 4,000. The ALJ should have pointed that out in the decision.
4,000.
Okay.
Yep.
1219.
Accept.
Accept.
1220.
Did we notify this guy because he asked to appear? I realize you don't read that.
We did not. We can hold it over to have him show
Have
up
him
here.
show up because he actually wrote it on. That's the one I called you, but I know you don't send those out, but he actually affirmatively asked.
Okay, we'll do that.
Ask him to appear 7/17.
7/17.
1221, 1222.
I'll accept just because of their good history. 15,000.
15,000. Yes.
1223.
He said they had an open night stabbing.
Yeah, this is open 10 days and went off the rails. I'm going to cancel them off.
Yeah, cancel bond.
1225.
Accept.
Yep, accept.
1226 and 1227.
Accept.
Accept.
1228.
1228, 3,000.
3,000.
1229.
Accept.
6,000, accept.
1230.
Accept.
Accept.
1231, 32, 35, 36, 37, 38, 39.
No controversy.
So sustain 1, dismiss 2, sustain 3, dismiss 4. Second proceeding, sustain 1, dismiss 2, 3, and 4. Third proceeding, dismiss 1 and 2. Fourth proceeding, dismiss 1, sustain 2, 3, and 4. Fifth proceeding, sustain 1.
Oh, so you did there. Hold on.
Fifth proceeding, sustain 1. You don't have that?
No, I'm looking. There was something Mr. Allen, but I think it was on the.
It was on the other one.
Yeah, the other case.
Yeah, it was on. Yeah, he didn't put anything in this one. So on the sixth proceeding, that's a dismiss. Dismiss count 1 in the sixth proceeding. Seventh proceeding, sustain 1, 2, and 3. Dismiss 4, and I'm going to sustain 5, even though the ALJ dismissed 5 because I think that there was failure to supervise. There was a sale to a minor. There was a failure to comply.
Kind of all adds up, doesn't it?
Yeah, there was no. There was a minor in the basement when people were drinking and shouldn't have been. All that to me is all lack of supervision. That's my opinion. I'm at. Is this Alan? Where are you at, Commissioner?
A steep fine or closing down. I'm at 20,000. I think that may be too generous.
Yeah, I think it was 25,000.
25,000.
Looks at it, I think we keep them on the side of it.
No, you can take. You can
go ahead and act.
Yeah, you can act.
Commissioner Ford, you go to standing charge 5.
Yes, yeah, at 25,000.
Took you how you at?
Yeah, right.
1240.
I'm going to counter at 9,000. They had a notice after the first sale. You don't get a discount.
9,000.
1242.
Dismiss 1.
Yeah, I agree. I think the security did do good on this one. So 1242 dismiss.
1243.
Accept.
4,500.
1247.
I'm going to ask that call them in.
Okay.
To,
Ford, you good with that?
Yeah,
717.
717. Yeah.
1248.
So we got, what happened here, Ron?
The court,
they remanded it back for a hearing, all right? So we don't need to do anything. We just need to.
Just officially no appeal, and then.
Yeah, no appeal, so council can do the hearing. And now it's over.
Yep.
1250.
Or they can take it. I assume they don't want an offer, but you can do an offer too. I'll accept.
6,000 accept.
1251.
I'm going to go with a letter of warning. Moose Lodge.
Yeah, letter of warning.
1252.
3,000.
Sale to non-member. 3,000.
1254.
Accept.
Accept.
1255.
Accept.
Accept.
1256.
Accept.
Accept.
1257, 58, 59, and 60.
Accept.
12.5 accept.
1263, 64, 65, and 66.
Cancel bond, couldn't agree more.
1267.
Cancel bond.
It's closed, right? Yeah, cancel bond.
1268.
Closed as well.
I'm going to go 2,000 because they've been open for 4 years. Actually, I'll go 1,000.
1268?
Yeah. They've been open since 77.
1,000, yeah.
You got it.
1269.
7 years of cleanness. Cancel bond.
Closed.
1270.
3,000.
and records charge.
1267 is what?
1270.
Oh, 1270.
And actually, I don't think there's a renewal on file yet, so we're about to expire.
So you said 3,000?
Yep.
Yep, 3,000.
1271.
Cancel and bond.
Yeah, cancel bond.
1272.
Cancel for the record.
Cancel for the record.
1273.
Accept.
7,000 accept.
1280 and 81.
Cancel and bond because,
We should be yanked.
yeah, I mean, that's 2 to 18-year-olds that were given notice on both occasions, and our history is horrendous.
They're at 44,000 counting.
Yeah, cancel and bond.
1282.
Cancel and bond.
Cancel bond.
1284.
3,500.
3,500.
1289.
It's an incorrect charge. We're employing a minor. Say books and records.
1289?
Yeah.
No.
No, that's not a minor. You're allowed 18 years old is legal.
Yeah,
sir.
18 is allowed.
Oh.
But the books, he wasn't on the books. So I'll do the letter for him.
All right.
1290.
Except, it is inconsistent, I will grant you that. If you
Yeah.
didn't know that,
Well,
it
they
makes
changed
no sense that you can actually not drink it.
because they didn't raise the ages of the employees.
No, I know.
All right. Here's the you learn something every day in this place.
1291.
Except,
Accept.
1292.
except,
Accept.
1293.
except,
Accept.
1294.
This is 5 times.
yeah, I'm canceling bond. This guy's on his 3rd consumption off the premises. So he doesn't really care what we do.
Yeah.
Cancel bond.
1295.
Accept,
Accept.
1296.
accept,
Accept.
1298.
accept,
Accept.
1299.
1,500 accept.
So I'm accepting it too. I just have a question for you, Mark. So the failure to supervise is based on charge 1 and 2. Do we do that now, or is he just doing this on his own?
I think Deputy Counsel Ogden has been discussing this with the younger attorneys.
Oh, all right, not to throw it in there. I mean, if we're doing it, we should always do it, or otherwise.
No, I think it's not.
Yeah. Okay.
1303 and 1304.
I'm fine with it. I'll adopt it.
Me too.
1309.
Accept.
6,000 accept.
1310.
I'll accept.
Accept.
1311. You need to confirm the date and also designate who's going to do the hearing.
So, for the record, this is a resolution from the County of Dutchess Legislature asking us to change the operating hours of liquor stores, which would require us to do a hearing in Dutchess County to take public comment. I'll do the hearing with either with acting counsel, assuming he's still acting counsel at the time, and Tom Donahue in Dutchess County. And what is the date?
August 27th. You'll actually be the hearing officer then.
August 27th, 2019. And if either one of you guys can't make it, then Adam as well. And if anybody can't make it, then we'll make adjustments because I realize that's vacation time. I do want to point out though that it appears that the county executive vetoed this resolution, and then the legislature overrode the veto, and the county executive appears to be either misinformed or doesn't understand how the hours are set within the county. We did not set the hours that currently exist in the county. Somebody correct me if I'm wrong.
No,
But
they set it.
the county set those hours years ago. And they're the ones who voted to, or the legislature at that time either voted to make those the hours. If they wish to change them, they have gone through the proper process to do that, and we will certainly have a public hearing to change them at their request. But he seems to be misinformed that we are the ones who instituted those hours. We had nothing to do with it.
Well, we approved it upon the request of
The Dutchess County, which we generally do unless there is significant public or industry outcry, and there was apparently not at that time. But he seems to say, or he does say in his veto message, I do not know how this county became the last in the state to enable extended hours of operations. And I would just reiterate that he appears to be confused, and perhaps he should go and read the county history to find out how those hours were instituted.
All right, then. So the next item is 1312.
Accept.
1313.
I have
Cancel.
1313. Yeah, no, so
1314.
Accept.
10,000 accept.
1316. Same licensee.
Accept.
Accept, yes.
1317.
Is 1,000 low enough or what?
Yes.
All right. 1,000's good.
1318.
1318, 4,500 accept.
Accept.
1319.
Yep. Just on that one, they're producing evidence that they had a clerk that's trained under ACAP already.
Which one are you
1318.
No, 18. Yeah, but that happens.
We-
that happens by secretary.
That happens afterwards, once we confirm that there was actually.
Oh, you'll do that?
Yeah. And then they'll get the 1,000 even though they have another charge?
Well, no, you have to, the reduction is only for that charge.
Oh, so we have to split it. All right, so 3,000 on the sale of minor, 1,500 on the unauthorized trade name. And you can reduce that based on the ACAP.
$13.19.
Accept.
Accept.
$13.20.
Accept.
6,500 accept.
$13.21.
I'll grant reconsideration to accept the fine.
Same here.
$13.22.
Cancel and bond.
Cancel bond.
$13.23.
Counter 10,000. Open not even a year and they're a focal point already.
Yep, counter 10.
$13.24.
Sustain 1, 2, and 3. Dismiss 4. Sustain 5, 6, 7, and 8. Okay.
Well, they haven't opened a year yet.
No, I actually looked at this because the lawyer says they're cabaret, and I went and looked at their application, and the application indicates they are a restaurant. This guy rented the whole place out to promoters with hookah, never operated as a restaurant, it appears from day one. And they also indicated in their application they would not use promoters, so I'm at revoking bond.
Revoking bond.
$13.26.
We still have 3 cases pending? Oh, so let me go through this. Dismiss 1, sustain 2, dismiss 3, sustain 4, dismiss 5, sustain 6 through 27, dismiss 28, dismiss 29, sustain 30. And it appears there's 3 count cases still.
Yeah, there's 4 cases.
4 cases pending, revoking bond.
Yep, revoking bond.
$13.27.
2,500.
1328.
1327, you said 2,500?
Yeah, yes, that's what I put your hand out.
All right, yep, go ahead.
1328.
Accept.
1329.
Accept.
6,500, accept.
1330.
February through May.
Yeah, 2,500.
2,500.
1331.
Accept.
500, accept.
1332.
Accept.
6,000, accept.
1334.
Accept.
Accept.
1335.
Accept.
Accept.
1336.
4,000.
4,000. We have this one gentleman still
Yes.
waiting.
Is it Mr. Jacome? Is your attorney here yet?
No, sir. We are willing to offer 4,000.
Yeah.
Do you want to proceed, or you want me to held over to the next meeting?
No, we can sell.
You are? Okay. We'll accept the 4,000.
All right.
You'll
Thank
get,
you, sir.
You'll get something in the mail.
Thank you, sir. Have a good day.
I have nothing else. Chairman, do you have anything else?
No, thank you.
Then we are adjourned.
Thank you.
Thank you.